Meanwhile, former International Criminal Court Chief Prosecutor Luis Moreno Ocampo has in recent years reinvented himself as Israel's chief counsel. On his periodic trafficking to Israel, he heaped praise on its respect for the rule of law, purported that the legal status of Israeli settlements in the occupied Palestinian territories was a completely new and open question, even as the 15 judges on the International Court of Justice unanimously declared them illegal more than a decade ago. 131, and alleged that as a matter of law, protective edge was highly complicated. 132 It's unclear exactly where the complication lay. Was it when Israel dropped more than 100 one-ton bombs on Shuja'iyya, or when it indiscriminately fired 20,000 high-explosive artillery shells in densely populated civilian areas? Was it when Israel methodically razed to the ground thousands of civilian homes, or when it fired on civilians carrying white flags? Was it when Israel targeted clearly marked ambulances, or when it targeted clearly marked civilian shelters even after explicitly promising not to target them? His Israeli audiences no doubt warmed up to Moreno Ocampo's soothing words, whereas the informed reader cannot but shudder in revulsion at these wanton acts of criminal prostitution. 133. Lancet. Red Cross, International Criminal Court. The capitulation was as pervasive as it was pathetic. In yet another abject spectacle of professional dereliction, even the UN Human Rights Council betrayed Gaza after protective etch. Addendum. The critique of Black Friday in this chapter was submitted to Amnesty International for comment. This addendum includes a slightly edited version of Amnesty's response, which is reprinted with its gracious consent, and this author's rejoinder. Rejoinder to Amnesty's response. The crux of this chapter's argument with Amnesty International boils down to a single question. Did Israel primarily set out to target Gaza's civilian population or legitimate military objectives during Operation Protective Edge? Whereas Amnesty's factual evidence overwhelmingly affirmed the former, its legal analysis of this evidence consistently presumed the latter. In other words, its legal analysis repeatedly contradicted its own evidentiary findings and effectively exonerated Israel of the most explosive charge leveled against it. Amnesty's multiple reports on protective edge analyzed the assault at 3 discrete levels: individual incidents, example a single home; major attacks, example Rafah; and the operation as a whole. At each of these levels, Amnesty's legal analysis reached a similar conclusion: Israel might have committed war crimes in the course of pursuing legitimate military objectives, but it almost never intentionally targeted civilians. For example, in Families Under the Rubble, which analyzed Gazan homes targeted by Israel that resulted in large numbers of civilian deaths, Amnesty divined a possible military objective in each and every attack. In Black Friday, which investigated Israel's assault on Rafah, when its insane and crazy use of firepower peaked, Amnesty still divined a possible military objective in all but 2 of the 15 separate incidents it analyzed. Black Friday accordingly concluded that Israel may have targeted civilians and committed crimes against humanity in at most some instances. But the evidence assembled by Amnesty in Black Friday pointed ineluctably to a very different conclusion. At the micro and macro levels, the assault on Rafah was a premeditated and deliberate attack on a civilian population. It constituted a crime against humanity. Instead of engaging this chapter's specific criticisms of Black Friday, Amnesty's response for the most part lapses into broad, and often at best tangential, generalities. It is consequently inadequate to the task at hand. The devil is in the details, and by evading the details, the response cannot convince. This brief rejoinder will focus on the few substantive arguments Amnesty does endeavor to make. The italicized text is culled from its response. 1. Presuming that a particular attack was premeditated, or that an entire lengthy military operation such as Israel's Operation Protective Edge was designed to punish, humiliate, and terrorize a civilian population, is not an option for judges or juries in courts that adhere to international standards. Amnesty appears to invert the criticism leveled at it. A juxtaposition of the factual evidence Amnesty gathered in Black Friday. Against the legal analysis it rendered demonstrates that in incident after incident Amnesty itself kept presuming that the Israeli attack did not premeditatedly target civilians, notwithstanding its own factual evidence clearly showing that it did. Amnesty itself was presuming against its own evidence and in favor of Israel. For a typical example, see Table 11, adapted from Table 10 above. The legal analysis Amnesty presented was premised on a hypothetical scenario, divorced from the actual facts, that shielded Israel from the politically explosive charge of targeting civilians. It is instructive to compare Amnesty's chain of deductions in another of its regional reports issued contemporaneously. In Bombs Fall from the Sky Day and Night, Civilians Under Fire in Northern Yemen. 2015, Amnesty stated, "The evidence from attacks on military objectives, infrastructure, government buildings, moving vehicles, and other targets elsewhere in Yemen indicates that coalition forces are capable of striking their chosen targets with a certain degree of accuracy." In investigations into airstrikes in other parts of the country, Amnesty International found that Houthi/Saleh loyalist-controlled military bases or other military objectives had been repeatedly targeted by coalition airstrikes. Yet researchers found civilian objects in Saida Governorate which had been struck more than once, suggesting that they were in fact the intended target of the attack. For example, in at least 4 of the airstrikes investigated by Amnesty International, houses were struck more than once, suggesting that they were the intended targets. Amnesty International also visited 6 markets in and around Saida city that were struck by airstrikes and analyzed video footage of the aftermath of airstrikes on a number of markets in other nearby towns and villages. Some markets were attacked repeatedly on separate occasions, at times of day when many civilians were present. Amnesty International found no evidence indicating that the markets had been used for military purposes. The evidentiary standard used by Amnesty in the Yemeni case was this: if a belligerent possesses weapons capable of striking chosen targets with a certain degree of accuracy, and if civilian objects were attacked repeatedly on separate occasions, at times of day when many civilians were present, and if Amnesty found no evidence indicating that the civilian objects had been used for military purposes, then it suggests that the civilian population was in fact the intended target of the attack. But then didn't Israel's saturation bombing, precision missile attacks, and intensive artillery shelling of Rafah's densely populated civilian neighborhoods, stretching non-stop over a 4-day period and in the near-total absence of a legitimate military target, suggest that the civilian population was the intended target of the attack? Put otherwise, why didn't Amnesty enter the weasel caveat in the case of Yemen? Amnesty International found no evidence indicating that the markets had been used for military purposes. Even if there had been a military target, the distortions that set in from Amnesty's modus operandi became yet more painfully and nauseatingly apparent in a document it issued 2 years after Protective Edge, which deplored the lack of accountability for atrocities committed during the Operation. 135 It recalled the details of a notorious incident in which 4 Palestinian children, aged 10 to 14, were killed while they played hide and seek on the beach. The attack took place in full view of international journalists. They could see clearly that the people running across the beach were children, an Israeli military spokesman announced. That the attack was targeting a Hamas Naval Forces compound, which journalists described as a small, broken-down fisherman's hut. None of the journalists reported seeing military operatives in the vicinity of the hut. What did Amnesty conclude from this accumulation of damning evidence? At the very least, the attack failed to take required precautions to protect civilians, including to ensure that targets are of military nature before proceeding with an attack. Is it the mandate of a human rights organization to report what at the very least happened or, based on all the available evidence, what probably happened? Amnesty noted that an Israeli investigation absolving the military of responsibility for the killings did not explain why the army had not identified the children as such. It couldn't even conceive, or wouldn't let itself conceive, that the IDF had identified 4 children frolicking on a beach as such and then proceeded to murder them. 136. The response alleges that bodies bound by international law do not have the option of concluding that the carnage in Rafah was designed to punish, humiliate, and terrorize a civilian population. But the internal quote comes from the Goldstone Report on Operation Cast Lead, 2008-9. 137. It is a depressing commentary that Amnesty now distances itself from Goldstone, although it previously issued no less than 15 statements embracing the report. 138. For example, one of these Amnesty statements declared, "All relevant UN bodies must act promptly and in coordination to implement the recommendations of the unmandated Goldstone Report on violations of international law." The report's findings are consistent with those of Amnesty International's own field investigation. Key findings of the Goldstone Report include: Israeli forces committed violations of human rights and international humanitarian law amounting to war crimes and some possibly amounting to crimes against humanity. Notably, investigations into numerous instances of lethal attacks on civilians and civilian objects revealed that the attacks were intentional, that some were launched with the intention of spreading terror among the civilian population and with no justifiable military objective. 139. The bigger point, however, is this. In its objectives and modus operandi, Protective Edge did not substantively differ from Cast Lead, except that the devastation wreaked by Protective Edge was on a vastly greater scale. On the basis of the evidence collected by it, the Goldstone Report concluded, and Amnesty's own findings corroborated, that Israel deliberately targeted Gaza's civilian population in numerous instances. Yet although the evidence assembled by Amnesty's Protective Edge reports in general and Black Friday in particular pointed to the same conclusion, Amnesty's legal analysis inferred, hypothesized, or speculated to the contrary that Israel almost without exception targeted not the civilian population but instead legitimate military objects. It is also unclear why Amnesty did not as a matter of law have the option of concluding that Israel sought to punish, humiliate, and terrorize Gaza's civilian population in Protective Edge. Indeed, Black Friday itself found that Israel committed carnage in Gaza in a desire for revenge, to teach a lesson to, or to punish the population. Barely a flea's hop separates this factual description of the Rafah massacre from the phrase punish, humiliate, and terrorize that Amnesty alleges it did not have the option to utilize. The real problem would appear to be that in its legal findings Amnesty took flight from its own factual findings of what happened. In its response, Amnesty reprimands this author, as he allegedly fails to consider the body of evidence we made publicly available. But isn't it Amnesty that failed to consider this, that is, its own body of evidence? 2. We cannot necessarily assume that there was no legitimate military target for each specific Israeli attack just because we did not uncover information pointing to one. Since the Israeli military used targeted munitions such as drone-fired missiles during the assault on Rafah, in addition, obviously, to the use of massive amounts of artillery and other area weapons, and since Palestinian fighters and military installations were present in at least some parts of Rafah during the hostilities, we have to entertain the possibility that each Israeli attack had a legitimate military target. The most we can say is that after various types of research, we have not been able to discover a legitimate military target for a particular attack. This does not mean we necessarily believe there was one. The essence of this statement is, whenever Israel uses precision weapons, Amnesty cannot necessarily assume that there was no legitimate military target. Indeed, it must entertain the possibility that there was one. Even if all the available evidence points to the conclusion that Israel was targeting civilians. This acknowledgement intrigues on multiple counts. First, whereas it earlier argued against presuming that Israel targeted civilians, here Amnesty itself argues in favor of presuming that Israel targeted a military objective whenever it used precision weapons, and even if all the available evidence demonstrates otherwise. Second, Amnesty reverses the intuitive presumption that if precision weapons are used in an attack that results in civilian deaths, and no evidence exists of a military objective, then precisely because precision weapons were used, the attack on civilians must have been deliberate. Instead, Amnesty declares that if precision weapons were used, the presumption must be that Israel did not target civilians, even as all the evidence points to the conclusion that it did. Amnesty provides no basis for its poignant presumption that Israel would not use precision weapons to target civilians, although voluminous evidence exists that Israel has repeatedly and brazenly targeted civilians, including children and civilian objects, much of it collected by Amnesty itself. Third, if it is incumbent upon Amnesty to entertain the possibility that Israel's objective was a legitimate military target when it used precision weapons, then Amnesty by definition cannot find that Israel targeted civilians when it used precision weapons unless Israel itself confesses, because the possibility will always exist that its objective was a legitimate military target. In other words, if Amnesty did not find that Israel was targeting civilians, it was not for a deficit of evidence. Indeed, it was despite overwhelming evidence, much of it emanating from Israelis themselves, but because it was an epistemological impossibility. On the one hand, its working presumption was that Israel did not target civilians when it used precision weapons, while, on the other hand, the logic of its reasoning was such that no amount of evidence could persuade it otherwise. It's worth pausing for a moment to ponder Amnesty's astonishing assertions. A typical human rights report includes a section on international law that cites the relevant provisions of international humanitarian and human rights law. For example, the legal chapter of Black Friday includes these subheadings: prohibition on direct attacks on civilians and civilian objects, the principle of distinction, prohibition on indiscriminate and disproportionate attacks, precautions in attack, precautions in defense, collective punishment, investigation, and international human rights law. All these sections cite from standard sources, such as the 1949 Geneva Conventions and additional protocols I and II, adopted in 1977. But unbeknownst to its readers, Amnesty interposes between its factual findings and legal analysis a phantom special presumption for Israel, let's call it SP4I, according to which, whenever Israel deploys precision weapons, the operative presumption must be that it is targeting a military objective, and, even if all the evidence demonstrates otherwise, the possibility must still be entertained that a military objective was targeted. It ought to be obvious that SP4I is not anchored in any extant provision of international law, that this extenuating dispensation is applied only to Israel. Would Amnesty invoke such a presumption for the Syrian regime, and that no basis exists for it in Israel's extant record of conducting armed hostilities? If nothing else comes of this exchange, it's surely worthwhile that SP4I, hitherto invisible in Amnesty's legal analysis, has now been dredged to the surface. 3. Legally, there is no hierarchy among different types of war crimes or between war crimes and crimes against humanity. All are considered the most serious crimes of concern to the international community as a whole, which must not go unpunished. In terms of war crimes, legally speaking, intentionally launching an attack in the knowledge that the attack will cause civilian casualties or damage to civilian objects that would clearly be excessive in relation to the concrete and direct military advantage anticipated, i.e. a disproportionate attack, is just as criminal as intentionally launching a direct attack on civilians or civilian objects, or an attack which strikes military objectives and civilians or civilian objects without distinction, or which treats as a single military objective a number of distinct military objectives located in a civilian city or town. All are prohibited by IHL and all are war crimes. If a hierarchy does not exist among war crimes, it is cause for wonder why Amnesty is so cautious not to accuse Israel of intentionally targeting civilians, and why it starts from the presumption that Israel was not targeting civilians, and why it persists in this presumption even if all the evidence it gathered showed that Israel was targeting them, and why, a contrario, in a press release for the Amnesty report deploring lack of accountability 2 years after Protective Edge, it chose to highlight several attacks that clearly targeted civilians. In violation of international humanitarian law. 140 But, of course, a hierarchy does exist, if not in a strictly legal sense then as a political matter. The public's threshold of tolerance is much higher for civilian deaths in an operation that targets legitimate military objectives than for civilian deaths in an operation calculated to punish, humiliate, and terrorize the civilian population. A 2016 International Committee of the Red Cross survey found that only half of public opinion among the 5 permanent members of the UN Security Council, and Switzerland, believed it was wrong to target enemy combatants in populated areas. Knowing that many civilians would be killed, whereas fully 80% believed it was wrong to target hospitals, ambulances, and healthcare workers in order to weaken the enemy. 141 What's more, if civilians are killed in the absence of a military objective, it's a straightforward grave breach of international law, akin to rape or the coercive use of human shields. However, the killing of civilians in the context of a military objective, which is what indiscriminate and disproportionate attacks presuppose, diminishes the probability of a conviction, as it introduces an element of murkiness and opens up wide latitude for judgment. The International Court of Justice couldn't even reach consensus that the use of nuclear weapons was disproportionate or indiscriminate in all circumstances, or, put otherwise, the categories proportionate and discriminate are so elastic that they can even accommodate the use of nuclear weapons. 142 Amnesty accuses Israel of committing disproportionate and indiscriminate attacks during its assault on Rafah, while it scrupulously avoids accusing Israel of premeditated attacks on the civilian population despite overwhelming evidence. This was clearly a political decision. Amnesty calibrated its legal findings so as not to incur the full force of Israel's wrath. The political decision, however, came at a heavy price. It shielded Israel from the full force of justified public outrage by whitewashing the ugliest truth about the Rafah inferno. It resulted not from the excesses of a legitimate military operation gone awry, but from an operation that ab initio intentionally targeted the civilian population. The remainder of Amnesty's response consists of self-congratulatory bromides or unargued counterclaims. Response to Norman G. Finkelstein's critique of Amnesty International's Black Friday Report 134. We consider that your critique misrepresents our work on the Israel/Gaza 2014 conflict, and our legal analysis disregards our efforts to campaign for justice for the victims of crimes committed during the conflict, and fails to consider the body of evidence we made publicly available from our joint investigation with forensic architecture. While we welcome substantive engagement with our work, including critical engagement, we reject entirely your conclusion that our Black Friday report represents a whitewash. Amnesty International, together with forensic architecture, chose to focus on investigating Israel's assault on Rafah from 1 to August 4, 2014 for a number of reasons. These include the ability of field workers in the Gaza Strip contracted by Amnesty International to obtain eyewitness testimonies and other relevant information, the amount of photographic and video material posted on media and social media in real time, which enabled analysts to reconstruct specific attacks and locate them in time and space, the availability of high-resolution satellite images of Rafah, including from 11:39 a.m. on August 1, 2014, when some of the heaviest attacks were being launched, and the fact that the Hannibal Directive had been invoked. This combination of factors led Amnesty International and forensic architecture to conclude that in spite of Israel's continued denial of access to the Gaza Strip to Amnesty International researchers during and after the 2014 war, strong evidence that Israeli forces committed crimes during the assault on Rafah could be obtained. Israel's violations of international humanitarian law, IHL, and crimes during Operation Protective Edge were certainly not confined to Rafah. Amnesty International has not implied that they were, in Black Friday, or any of its other publications on the 2014 war. and the organization has documented Israeli attacks in many areas of the Gaza Strip that it believes should be investigated as possible war crimes. In particular, Israel's massive use of artillery and other firepower on residential areas such as Shuja'iyah and Huzaifa bear many similarities to its assault on Rafah. Amnesty International uses international law as its framework to push state and non-state actors around the world to uphold human rights and protect civilians, including in situations of armed conflict, and to press for justice, truth, and reparation when rights are violated and crimes are committed. As part of that work, we rigorously gather evidence of violations and, based on our findings, analyze what occurred in light of the relevant international standards, primarily, but not exclusively, IHL in situations of armed conflict. We use our findings and legal analysis to campaign publicly and to make recommendations to governments, international bodies, and others in an effort to stop further violations and ensure redress for those already committed. We also engage with national and international investigatory mechanisms and judicial bodies, where appropriate. However, Amnesty International is not a judicial body. Our legal analysis is therefore neither an indictment nor a final judgment. Instead, it is presented in light of the information we have collected and in order to support the recommendations we are making to governments, international bodies, and others. In conducting our legal analysis on specific cases, particularly those that may amount to crimes under international law, we are mindful of the standards of evidence and the burden of proof that would be necessary to make such an argument before a competent court, which are far higher than those used to make a particular argument in an academic or journalistic article. We are also mindful of the fact that, even in cases when crimes under international law are committed, anyone prosecuted for committing or ordering such crimes has a right to fair trial proceedings, including the presumption of innocence until proven guilty on specific charges. Presuming that a particular attack was premeditated, or that an entire lengthy military operation such as Israel's Operation Protective Edge was designed to punish, humiliate, and terrorize a civilian population, is not an option for judges or juries in courts that adhere to international standards. Our remit is to rigorously gather, assess, and publicize information documenting violations and to campaign for justice and reparation for victims and their families, all tasks that we have undertaken during and after the Israel-Gaza war in 2014. Our outputs have consistently been widely reported on by the media, keeping justice for victims firmly on the agenda, and have been noted by governments and judicial bodies, including the Office of the Prosecutor of the International Criminal Court, ICC, which is conducting a preliminary examination on Palestine. Our efforts to end impunity for those responsible for war crimes and other violations of IHL in Israel and the occupied Palestinian territories, OPT, including but not limited to those committed during the 2014 Israel-Gaza war, will continue. Within our limited resources and other constraints, we do our best to conduct this work in a way that is strategic and will contribute to achieving genuine long-term human rights change. This, rather than criticism of our work on Israel and the OPT from various standpoints, is what guides us. In situations of armed conflict where a military force possesses and uses sophisticated weaponry, part of the factual and legal analysis Amnesty International must conduct is indeed trying to understand and evaluate the premises used by the military planners and decision-makers, which is not the same as condoning them. In other words, we need to consider whether there was, or could have been, a genuine military objective for each Israeli attack analyzed, even when the attack occurred in a context like the assault on Rafah during 1–4 August 2014, where the scale and toll of the Israeli attacks cannot possibly be justified by the objective of preventing the capture of one Israeli soldier. Military targets could include Palestinian fighters and military objectives, such as installations or structures used for military purposes, weapons and ammunition stores. Other objects which are not necessarily military in nature, including tunnels and civilian homes or other buildings, may become military objectives when they are used at the time of the attack to make an effective contribution to military action, and if their destruction or capture offers a definite military advantage in the circumstances ruling at the time. The Israeli authorities do not release sufficient information on targets and specific objectives to enable a full assessment of their legality, a fact for which we have consistently criticized them. Nevertheless, in the context of the hostilities in Rafah on 1–4 August 2014, and more generally during the Israel-Gaza 2014 war, we cannot necessarily assume that there was no legitimate military target for each specific Israeli attack just because we did not uncover information pointing to one. Since the Israeli military used targeted munitions such as drone-fired missiles during the assault on Rafah, in addition, obviously, to the use of massive amounts of artillery and other area weapons, and since Palestinian fighters and military installations were present in at least some parts of Rafah during the hostilities, we have to entertain the possibility that each Israeli attack had a legitimate military target. The most we can say is that after various types of research, we have not been able to discover a legitimate military target for a particular attack. This does not mean we necessarily believe there was one. It is even harder to determine the intent of a particular attack based on the available information, since even when targeted weaponry is used, IHL allows for the possibility that a reasonable commander bases a decision on the information available to him/her at the time and makes a mistake. Basically, we have to analyze each case and present our conclusions in a deliberately cautious and considered manner, which often means stating the minimum that could be concluded about the case rather than the maximum. With the cases in the Black Friday report, we believe we have indeed made a strong argument that even when they are considered from the standpoint of a reasonable commander, the cases should be independently investigated as war crimes and individuals should be held criminally liable. In other words, the strategy is in fact similar to what you surmise when you stated, amnesty entertains so many of Israel's premises, or premises favorable to Israel, in order to show that, even if one were to accept those premises, Israel would still be legally culpable, emphasis in original. We believe this strategy is the correct one to employ if we want to move closer to Israeli military or political personnel being prosecuted for their responsibility for war crimes. Consequently, we reject your criticism that this strategy winds up misrepresenting what happened and letting Israel off the hook on the more serious legal charges. Legally, there is no hierarchy among different types of war crimes or between war crimes and crimes against humanity. All are considered the most serious crimes of concern to the international community as a whole, which must not go unpunished. When sufficient admissible evidence exists, all states are permitted and, sometimes, obliged to bring to justice any person responsible for committing or ordering these crimes, regardless of which category of war crime was committed or whether it was an act committed as part of a crime against humanity. Crimes against humanity are defined in Article 7 of the Rome Statute of the ICC, and include acts such as murder when committed as part of a widespread or systematic attack directed against any civilian population, with knowledge of the attack. In terms of war crimes, legally speaking, intentionally launching an attack in the knowledge that the attack will cause civilian casualties or damage to civilian objects that would clearly be excessive in relation to the concrete and direct military advantage anticipated, i.e. a disproportionate attack, is just as criminal as intentionally launching a direct attack on civilians or civilian objects, or an attack which strikes military objectives and civilians or civilian objects without distinction, or which treats as a single military objective a number of distinct military objectives located in a civilian city or town. All are prohibited by IHL and all are war crimes. In cases where Amnesty International was unable to determine whether an attack which killed or injured civilians was aimed at a military objective, we stated, depending on the particular circumstances, that the particular attack was disproportionate or otherwise indiscriminate if not a direct attack on civilians or civilian objects. It is simply incorrect to argue that the organization was somehow seeking to minimize Israeli crimes or ignoring the fact that the attack was committed as part of a 4-day military assault seemingly motivated by a desire to exact revenge or punish the civilian population of Rafah. You appear to confuse our analysis of specific attacks within the Israeli assault on Rafah with our analysis of the overall Israeli assault. We are not categorizing the Rafah massacre as a disproportionate attack, an indiscriminate attack, or a failure to take all feasible precautions on account of Israel's intent to kill Golden. As described above, each attack must be analyzed individually, and then conclusions can be drawn about the 4-day assault in which the attacks took place. Nevertheless, we strongly disagree that our analysis amounts to legitimizing the wholly illegitimate goal of launching an armed attack in order to preempt a future prisoner swap. Nor does using language such as shift in proportionality to refer to the logic of the Hannibal Directive and the logic of the Israeli military in implementing it imply that we are somehow endorsing that logic. In our report, we considered what we know about the Hannibal Directive, since the actual directive is classified, and the way it was implemented in Rafah from 1 to 4 August 2014, we absolutely did not endorse, in any way, either the directive or the way it was implemented. Arguing that we did so would misrepresent our report. 13. Betrayal 2. UN Human Rights Council. In August 2014, the UN Human Rights Council appointed a fact-finding mission to investigate purported violations of international humanitarian and human rights law during Operation Protective Edge, 2014. 1 William Shabbos, a respected international jurist, was named chair of the mission. Israel immediately jumped into high gear to oust him, as he had previously uttered sacrileges such as, "Why are we going after the president of Sudan at the International Criminal Court for Darfur and not the president of Israel for Gaza?" Foreign Minister Avigdor Lieberman weirdly analogized Shabbos's recruitment to appointing Cain to investigate who killed Abel. Unable to withstand the juggernaut, Shabbos duly resigned and was replaced as chair by a U.S. judge, Mary McGowan Davis, who hailed from New York State. 2 The outcome at this point was as predictable as when UN Secretary-General Ban Ki-moon appointed Alvaro Uribe vice chair of the panel of inquiry after Israel's assault on the Mavi Marmara. 3 The betrayal had begun. In June 2015, the UN Human Rights Council, UNRWA, mission released its report for it predictably accused Hamas 5 of having committed war crimes. But a close reading of the UN report could not have pleased Israel either. In its discrete analyses of numerous incidents during the assault, the report's factual findings repeatedly suggested that Israel might also have committed war crimes. A reader unfamiliar with the facts would perhaps be impressed at the report's even-handed presentation, whereas a reader familiar with them would probably recoil in outrage at this spurious balance. The odd thing about the report was that it did chronicle, often in harrowing detail, the horrors that Israel inflicted on Gaza. However, it then proceeded to render legal analyses that methodically and, in many instances, comically buffered the gravity of Israel's crimes. In other words, it precisely replicated the apologetic modus operandi of the Amnesty International reports on Protective Edge. 6 The upshot was that the UN report conveyed a wholly misleading, distorted picture of what happened in Gaza. Whereas it suggested that Protective Edge was a legitimate military campaign lamentably marred by sundry excesses, in fact the assault was a terror campaign designed, if not to break, then at any rate to temper Gaza's will to resist. In order to convincingly demonstrate the report's bias, there's no alternative except to sift through its findings piecemeal fashion. It is to be hoped that by the time readers complete this chapter, they will be persuaded that if this writer has reached a harsh conclusion, it springs neither from malice nor prejudice but was arrived at only after scrupulously parsing the evidence, albeit also amid his mounting feelings of despair commingled with indignation that even at this late date, when a seemingly endless river of blood has passed under the bridge in the course of Israel's numberless operations targeting the martyred people of Gaza, a document bearing the imprimatur of the Human Rights Council should still so want in courage and integrity. The UN report on Protective Edge did not lack in redemptive features. It confirmed previous authoritative statements of law on a number of critical points. Thus, it reiterated that the occupied Palestinian territory is comprised of the West Bank, including East Jerusalem, and the Gaza Strip. 7 It also concluded, after painstaking analysis, that despite its ballyhooed 2005 redeployment, Israel has maintained effective control of the Gaza Strip. Gaza continues to be occupied by Israel. 8. The report went on to state that the blockade of Gaza by Israel has been strangling the economy in Gaza, that the dire situation in Gaza since the end of Protective Edge cannot be assessed separately from the blockade imposed by Israel, and that current international relief efforts are not a substitute for lifting the blockade. 9. The most resonant pronouncement in the whole of the report called on Israel to lift, immediately and unconditionally, the blockade on Gaza. 10. On another charged legal point, the report rejected Israel's contention that if it could avert the capture of one of its soldiers, resort to otherwise disproportionate force would be legitimate. The proportionality test, Israel had argued, must take into account the strategic consideration of denying the armed groups the leverage they could obtain over Israel in negotiations for the release of the captured soldier. The report persuasively rejoined that this line of reasoning constituted an erroneous interpretation of international humanitarian law. The leverage that armed groups may obtain in negotiations does not depend solely on the capture of a soldier, but on how the government of Israel decides to react to the capture in the aftermath. The strategic military or political advantage sought is therefore not a concrete and direct military advantage as required by international humanitarian law. Indeed, the proposed interpretation of the anticipated military advantage, which would allow for abstract political and long-term strategic considerations in carrying out the proportionality analysis, would have the consequence of emptying the proportionality principle of any protective element. Point 11. Still, these various legal determinations contained in the report, although to be welcomed, did not remotely vindicate its numerous problematic, and at times outrageous, findings. The UN report's mandate formally covered only jus in bello, rules governing the conduct of armed conflict, and not jus ad bellum, rules governing the resort to armed conflict. However, its pronouncements on the triggers of Protective Edge effectively justified the Israeli offensive. It neutrally began. The hostilities of 2014 erupted in the context of the protracted occupation of the West Bank, including East Jerusalem, and the Gaza Strip, and of the increasing number of rocket attacks on Israel. 12. But then, crossing into the juridical terrain of jus ad bellum, the report cited without caveat Israel's public rationales for launching the initial air assault and subsequent ground invasion. 13. On July 7, 2014, the Israel Defense Forces commenced Operation Protective Edge in the Gaza Strip, with the stated objective of stopping the rocket attacks by Hamas and destroying its capabilities to conduct operations against Israel. On July 17, 2014, the IDF launched a ground operation into Gaza. Official Israeli sources indicated that they did so to degrade terror organizations' military infrastructure, and neutralize their network of cross-border assault tunnels. 14. But as a matter of law, Israel couldn't resort to armed self-defense unless it had exhausted nonviolent options and, hence, was driven by necessity to launch an attack. 15. In the event, Israel did have at hand an effective nonviolent remedy. Even egregious Israeli propagandists acknowledged that Hamas's objective from the inception of hostilities was to reopen Gaza's borders. 16. The World Bank reported at the time that access to Gaza remains highly controlled, while Amnesty had deemed the siege a form of collective punishment, and the UN report itself called on Israel to lift, immediately and unconditionally, the blockade on Gaza. 17. It follows that if the cessation of Hamas rocket attacks was Israel's objective, then it only had to terminate its suffocating siege of Gaza, which would have put Israel on the right side of the law and preempted its necessity of armed self-defense, while sparing Gazans a murderous assault and allowing them, finally, to breathe. But what about Hamas's cross-border assault tunnels? For argument's sake, let's say that they posed a lethal threat. What prevented Israel from sealing the tunnels from its side of the border, as Egypt did to block cross-border tunnel traffic and raids between Gaza and the Sinai? 18. Indeed, in mid-2016, Israel declared plans to build a concrete wall tens of meters deep underground and above ground to counter the threat of Hamas attack tunnels. 19. Earlier in the year, the Defense Ministry announced that a solution for the tunnels would cost several $100 million, but that such funding has not been earmarked in the defense budget for the coming years. Which would seem to indicate that Israeli leaders didn't attach special urgency to the danger posed. 20 It speaks to the report's deep-seated bias that it didn't even ponder Israel's options short of armed force, but instead blithely repeated Israeli Hasbara propaganda. The UN report perfectly balanced its overall verdicts on protective edge, high incidence of loss of human life and injury during the 2014 hostilities is heartbreaking. Palestinians and Israelis were profoundly shaken by the events of the summer of 2014. The 2014 hostilities have had an enormous impact on the lives of Palestinians and Israelis. The scale of the devastation was unprecedented, and the death toll and suffering from injuries and trauma speak volumes. The Commission was deeply moved by the immense suffering of Palestinian and Israeli victims, who have been subjected to repeated rounds of violence. 21 In general, balance is an admirable quality. It connotes nonpartisanship and objectivity. But balancing out a wildly imbalanced balance sheet amounts to a partisan act of misrepresentation. The findings of unappointed commissions in other situations do take note of grossly lopsided balance sheets. 22 To be sure, the report's space allocations were not quite so evenly distributed. The ratio of paragraphs devoted to breaches of international law by Israel versus Hamas came to 4:1,23, while the ratio of paragraphs in the chapter devoted to the human and material toll on Gaza versus Israel stood at 4:3.24. Still, although favorable to Gaza, these ratios didn't remotely approach the relative magnitudes of death and destruction during protective edge. Indeed, as the report itself documented, Israel killed as many Palestinian children in the West Bank, which wasn't even a theater of war, as the total number of Israelis killed during protective edge, and Israel destroyed more Palestinian homes in the West Bank than the total number of Israeli homes destroyed. 25 Whichever metric one zeroes in on, the colossal imbalance emerges in full view. See Table 12. The gross inequity registered in these ratios was barely perceptible in the report. For example, whereas raw data, such as total casualty figures, typically occupy a salient place in human rights documents and, accordingly, the number of Israeli fatalities showed up early in the report. 26 The figure for Palestinian casualties was buried deep inside its pages. 27 However much it played with these data, to credibly preserve its pretense to balance, the report nevertheless had to pour substantive content into its many paragraphs devoted to Israel's heartbreaking loss of life, devastation, and immense suffering. But callous as it might sound, the fact is there just wasn't all that much to say. How many lines could the report invest in the death of one Israeli child and the destruction of one Israeli home? It resolved this dilemma by effectively upgrading into a breach of the laws of war, even a quasi-war crime, Hamas's infliction of psychological/emotional distress on Israelis. In armed conflicts, human rights investigations properly focus on violations of the laws of war, in particular, intentional, indiscriminate, and disproportionate attacks on civilians and civilian objects. Thus, the Gaza section of the UN report's impact chapter overwhelmingly chronicled the massive death and destruction inflicted by Israel on Gaza's civilian population. Just 3 paragraphs at the tail end gestured to pervasive trauma and hopelessness in the strip. 28 However, the impact chapter's Israel section reversed these proportions. It prudently passed over in silence total Israeli civilian casualties and consigned the economic damage Hamas wreaked to 3 concluding paragraphs. 29 To exemplify this damage, it spotlighted a kibbutz member whose photography business in Beersheba stopped during the war as she was too afraid to take public transport, which made her run into debt together with many other members of the kibbutz. Instead, the report opened the Israel section with a profile of protective edge's psychological impact, and then proceeded to describe these effects with mind-numbing repetition, piling one anecdote of distress upon another of anxiety, as if even after contriving this unorthodox rubric to balance out the Gaza section, it still strained to fill space. See Table 13. International law forbids acts or threats of violence, the primary purpose of which is to spread terror among the civilian population. 30 However, the laws of war do not prohibit acts of violence that might induce some degree of terror among civilians, which is an unavoidable accompaniment and consequence of any substantial resort to armed force. 31 Otherwise, the laws of war would effectively outlaw major armed conflict. Their purpose, however, is not to eliminate war, a utopian goal, at any rate, at this juncture in time, but rather to minimize its destructiveness. The various anxieties, stresses, fears, and traumas experienced by Israeli civilians during protective edge appeared to fall into this category of states of being that, unpleasant and disorienting as they might be, normally and inevitably attend armed conflict. To tacitly put civilian stress and trauma on a par with civilian death and destruction undercuts the critical legal distinction between those acts of war that humanity has resolved to abolish, or contain, and those that to date it hasn't so resolved. If an Israeli civil defense siren set off by a rocket attack from Gaza caused anxiety among Israelis, it doesn't follow that Hamas breached the laws of war. In effect, the report overreached its legal mandate by stretching and, consequently, mangling the laws of armed conflict. Moreover, by equating conditions of suffering that these laws have endeavored to differentiate, it has homogenized situations that by common consent and as a point of law qualitatively differ. If Israelis experience the distress of not being able to leave their homes, Palestinians experience the distress of no longer having a home to which they could return. The report likewise failed to distinguish between situations so radically different in degree as to make them qualitatively incomparable. If Israelis experienced fear and incurred injuries en route to a shelter, then Gazans experienced fear of having nowhere to run in the midst of an inferno and then coming under deliberate attack or, if fortunate enough to find refuge in that rare shelter, of being slaughtered by Israeli precision weapons targeting it. If Israelis had to endure the concussive effects of bottle rockets, then Gazans had to endure the concussive effects of one-ton bombs. It cannot be doubted that the drafters of the report were cognizant of these elementary distinctions. They elected, however, to collapse them, not because of a high-minded sensitivity to the full gamut of human suffering, or an enlightened refusal to rank human suffering, but almost certainly because otherwise the report's pretense to balance could not be sustained. If the report had properly fulfilled its essential mandate to investigate violations of the laws of war during protective edge, the whole of the Israel section in the impact chapter could have been reduced to one sentence. 6 civilians were killed and 1 house was destroyed. The UN report's elevation of fear inducement into a breach of the laws of war similarly marred its treatment of the Hamas tunnel network. It did acknowledge that the tunnels were only used to conduct attacks directed at IDF Israel Defense Forces positions in Israel in the vicinity of the Green Line, which are legitimate military targets. 32 But still, it harped on the sense of insecurity and panic attacks, trauma and persistent fear, great anxiety, and so on that the tunnels engendered among Israelis. 33 It then proceeded to imply that the fear induced by these tunnels amounted to a violation of the laws of war. In its concluding observations, the report bracketed together these serious concerns regarding Hamas, the inherently indiscriminate nature of most of the projectiles directed towards Israel, and the targeting of Israeli civilians, which violate international humanitarian law and may amount to a war crime. The increased level of fear among Israeli civilians resulting from the use of tunnels was palpable. 34 Its final recommendations correlatively called upon Hamas to respect the principles of distinction, proportionality, and precaution, including by ending all attacks on Israeli civilians and civilian objects, and stopping all rocket attacks and other actions that may spread terror among the civilian population in Israel, emphasis added. The only other actions chronicled in the report were Hamas tunnel excavations/infiltrations. But if Hamas must desist from these below-ground excavations/infiltrations which target only combatants because they induce fear among Israelis, shouldn't Israel have to desist from above-ground attacks with bombs, missiles, and shells which overwhelmingly target civilians because they induce fear among Gazans? In addition, international law does not debar a people fighting for self-determination from resorting to arms, whereas it does prohibit a state suppressing such a struggle from deploying violent force. 35 Israel has deprived the people of Gaza of their right to self-determination via an externally imposed occupation. 36 Surely, then, Hamas has the right to target via tunnels Israeli combatants enforcing this occupation from without, however much anxiety these tunnel attacks might induce among the civilian population. Or are Palestinians permitted to use armed force only if it doesn't rattle Israelis? However ingenious the rhetorical strategies deployed by the UN report to even out Hamas's and Israel's breaches of international law, see Table 14 for another illustration, they still couldn't bridge the chasm separating the devastation inflicted, respectively, by each party. It is of course possible that even if it caused less death and destruction, Hamas might have committed as many war crimes as Israel. But it's also true that once the proportion reached an order of magnitude of, say, 550:1, children killed by Israel versus Hamas, or 18,000:1, homes destroyed by Israel versus Hamas, such a claim not only lacks plausibility but also appears positively ridiculous. How, then, did the report resolve this dilemma? It in part misrepresented the relevant facts, but more significantly it mangled the relevant law by repeatedly invoking relevant law. This disingenuousness permeated the report's treatment of Hamas and Israeli war crimes. Hamas war crimes. The UN report set the stage for its indictment of Hamas by citing directly or indirectly official Israeli sources depicting a formidable Hamas weapons arsenal. 37 But the battlefield performance of these weapons strongly suggested that the bulk of them consisted of little more than enhanced fireworks. 38 The report also dutifully regurgitated Israeli claims regarding the dazzling performance of the Iron Dome anti-missile defense system. 39 Even though recognized experts and the facts on the ground refuted them. 40 In an unusual acknowledgement, the report did observe that according to security experts, Hamas's declared official policy during Protective Edge was to focus on military or semi-military targets and to avoid other targets, especially civilians. 41 It went on to document instances in which Hamas appeared to be targeting Israeli combatants and military objects. While Israel itself acknowledged that Hamas mortar shells killed 10 IDF combatants positioned on the Israeli side of the border. 42 The report also observed that Hamas attempted in a few instances to warn Israeli civilians of impending attacks and, in fact, these Hamas alerts were more effective than those issued by Israel because unlike in Gaza, residents could flee to other areas of Israel less exposed to threats. 43 However, the report found that the vast majority of Hamas projectiles targeted population centers in Israel. 44 It devoted fully 15 paragraphs to depicting in graphic detail the effects of these Hamas attacks, even though only 6 civilians in Israel were killed and property damage was negligible. It is often suggested, although not by the report, that if so few civilians died it was only on account of Iron Dome, and a proper calculation would reckon the probable number of civilian deaths in its absence. The argument is factually false. Iron Dome probably didn't save many and perhaps not any lives, and even were it true, irrelevant, if additional civilians would have been killed absent Israel's civil defense/shelter system and structurally sound edifices. Should the casualty count then tally how many Israelis would have died if they lived in substandard, Gaza-like conditions? If a calculation were to be based on all things being equal, it abstracts from the root injustice that Israel and Palestine are not equal. The UN report found that Hamas's projectile attacks may have constituted war crimes. Hamas rocket attacks. Rockets cannot be directed at a specific military objective and therefore strikes employing these weapons constitute indiscriminate attacks. Statements indicate intent to direct those attacks against civilians. Hamas mortar attacks. Statements indicate in some cases intent to target civilian communities. If they were used to target civilians or civilian objects, this would be a violation of the principle of distinction, and the cases in which attacks were directed at military objectives located amidst or in close vicinity to civilians or civilian objects, mortars are not the most appropriate weapons. The imprecise nature of mortars makes it difficult for an attacking party using this weapon in an area in which there is a concentration of civilians to distinguish between civilians and civilian objects and the military objective of the attack. 45. In its defense, Hamas pleaded that Palestinian rockets are primitive and not very technologically advanced, but nevertheless the factions attempted to direct their rockets at military targets in Israel. 46. The report curtly and coldly rejoined, "The military capacity of the parties to a conflict is irrelevant to their obligation to respect the prohibition against indiscriminate attacks. The humanitarian rationale behind prohibiting use of indiscriminate weapons is self-evident. But, discriminateness is a relative notion. It varies according to the most sophisticated guidance system currently available for a particular line of weaponry. So it is equally self-evident that the prohibition against indiscriminate weapons discriminates against poor states or non-state actors that cannot afford cutting-edge technology. In the instant case, the report effectively criminalized nearly the whole of Hamas's primitive arsenal. And thereby it denied Gaza the inherent right, anchored in the UN Charter, of armed self-defense, and the right, effectively sanctioned by international law, of armed resistance in its self-determination struggle. Even if it is admitted that notwithstanding its discriminatory effects, cogent reasons might be adduced to preserve intact the prohibition, still it hardly befits a human rights document to peremptorily dismiss as irrelevant a wholly reasonable, if debatable, objection. It also warrants attention how much more sensitive the report was to Israeli concerns. For example, the report recognizes the dilemma that Israel faces in releasing information that would disclose in detail the targets of military strikes, given that such information may be classified and jeopardize intelligence sources. 47. Although it still placed the onus on Israel to provide sufficient details on its targeting decisions to allow an independent assessment of the legality of the attacks, the report not only evinced a sensitivity absent in its high-handed dismissal of Hamas, but it also credited the Israeli alibi that information was withheld out of security concerns, and not because its release might undercut official lies. The report proceeded to infer a sinister motive lurking behind Hamas rocket attacks. If these projectiles couldn't accurately target military objectives, then the report cannot exclude the possibility that the indiscriminate rocket attacks may constitute acts of violence whose primary purpose is to spread terror amongst the civilian population. 48. Spreading terror might have been Hamas's motive, but other possible motives also leap to mind. The rocket attacks could have been belligerent reprisals, which international law does not forbid. 49. To compel Israel to cease and desist from its terroristic assault on Gazan society. The report itself noted that Hamas issued a statement confirming its intention to target Israeli civilians in response to Israel's targeting of Palestinian civilians in their homes and shelters. 50. Or consider the motive professed by Hamas leader Khalid Mishal during Operation Cast Lead, 2008-9. Our modest, homemade rockets are our cry of protest to the world. 51. One wonders why the report did not entertain these more benign possibilities. International law requires all parties to a conflict to take all feasible precautions in the choice of means and methods of attack with a view to avoiding injury to civilians and damage to civilian objects. 52. The Union report alleged that despite substantial impediments to its investigation, it was able to divine patterns of behavior by Hamas that breached this legal obligation. 53. It cited a quartet of incidents where Hamas fired rockets in close proximity to civilians. 54. As it happens, Amnesty pointed to the identical 4 incidents in its indictment of Hamas. 55. The duplication suggests a paucity of corroborative evidence. The report also cited a handful of instances where Hamas conducted military operations within or in close proximity to sites benefiting from special protection under international law, in particular, the environs of 2 to 3 schools and a church. These incidents were also cited in earlier investigations. 56. The report further noted that official Israeli sources repeatedly accused Hamas of violating the feasible precautions obligation, but it was not able to independently verify these allegations. 57. The report acknowledged that the feasible precautions obligation is not absolute, that even if there are areas that are not residential, Gaza's small size and its population density makes it particularly difficult for armed groups. always to comply with the obligation, and that several signatories to the relevant international instrument stipulated that for densely populated countries, the requirement to avoid locating military objectives within densely populated areas would be difficult to apply. 58 Still, the report concluded that in light of the number of cases in which Hamas carried out military operations within or in the immediate vicinity of civilian objects and specifically protected objects, it does not appear that this behavior was simply a consequence of the normal course of military operations, and, therefore, the law was not always complied with. 59 Although this was a cautious and qualified finding, the question must nonetheless be posed: did the report substantiate it? It would have to show that the instances it documented gave proof of a deliberate Hamas choice not to avoid civilian and protected objects, and were not just random events consequent on the normal course of military operations in a densely populated civilian terrain. But the handful of incidents recycled by the report, during a 51-day armed conflict in which Hamas fired 7,000 projectiles and engaged an invading army with unprecedented combat losses on both sides, does not appear to reach the evidentiary threshold of a pattern. 60 The report not only failed to substantiate its qualified assertion but also indulged in groundless speculation. For example, it stated that if it is confirmed that in using locations to conduct military operations, armed groups did so with the intent to use the presence of civilians or persons, or to combat, to prevent their military assets from being attacked, this would constitute a violation of the customary law prohibition to use human shields and would amount to a war crime. 61 But the report didn't provide a scintilla of evidence demonstrating such intent. What was the point of such baseless conjecture, of which this is just one example? 62 Except to plant a false image in the reader's mind, or to appease Israel, which repeatedly accused Hamas of human shielding, or both. In its most audacious or outrageous speculation, the report verged on criminalizing nonviolent civil resistance as it posited that Hamas might wrongly exploit it. In one case of the bombing of a residential building examined by the Commission, information gathered indicates that following a specific warning by the IDF that the house was to be targeted, several people went to the roof of the house in order to protect the house. Should they have been directed to do so by members of Palestinian armed groups, this would amount to the use of the presence of civilians in an attempt to shield a military objective from attack, in violation of the customary law prohibition to use human shields. With regard to this incident, the Commission is disturbed by the reported call by the spokesperson of Hamas to the people in Gaza to adopt the practice of shielding their homes from attack by going up on their roofs. Although the call is directed to residents of Gaza, it can be seen and understood as an encouragement to Palestinian armed groups to use human shields. 63. Instead of showing compassion for Gazans as they risk life and limb to protect their and their neighbors' family homes, the report zeroed in on Hamas in order to deny it, on purely conjectural grounds, one of the few means of nonviolent resistance available to it in the midst of an annihilative attack, even going so far as to brand the Islamic movement's encouragement of such self-willed, here trending acts, whose spiritual lineage traces back to Gandhi 64, an embryonic war crime. It is also cause for sheer bewilderment why the report designated an unambiguously civilian dwelling as a military objective. Did it automatically lose its protected status once Israel decided to target it, or did the report start from the premise that everyone and everything in Gaza was, if not aligned, then alloyed with terrorism? Finally, the UN report indicted Hamas for its extrajudicial executions of suspected collaborators during protective etch. The fact that the majority of the victims had been arrested and detained before the conflict, it observed, prompts concerns that they were executed in order to increase pressure on Gaza's population, with a view to preventing others from spying. 65 Most executions occurred a day after 3 Hamas commanders were killed by the IDF. The report also noted that because of the stigma attached to collaboration, these executions had devastating effects on family members, who had to cope with indelible stains on their reputation and honor. Inasmuch as the report expressed sympathy for an alleged Israeli quandary, on releasing classified information, it might have paused to contemplate Hamas's quandary of resisting a brutal invasion while plagued by internal collaborators directly or indirectly on the payroll of the enemy. The Russian revolutionist Leon Trotsky cogently argued that in the midst of a foreign invasion, the threat of incarceration will not deter potential collaborators, because the very premise of aligning with the enemy is that its victory impends. They cannot be terrorized by the threat of imprisonment, as they do not believe in its duration. It is just this simple but decisive fact that explains the widespread recourse to shooting. 66. It is in no way to extenuate Hamas executions to pose the inescapable question: how else was Hamas supposed to deter collaborators? The prohibition on executing collaborators would appear to fall into the same category as the prohibition on indiscriminate weapons, an insoluble dilemma. It might be recalled that a leader of the Warsaw Ghetto Uprising expressed as our great guilt that immediately, from the first day, we didn't kill the Jewish collaborators. If a few of them had been killed, others would have been afraid to join the police. They should have been hanged on lamp poles, to threaten them. I'm sure that whenever there is internal treason, war must begin by destroying it. 67. The report determined that these Hamas executions, not may but unquestionably did amount to a war crime, and it exhorted, whoever is responsible for the killings must be brought to justice. 68. Nowhere in its indictment of Israel did the report use such unequivocal and emphatic language. It also called upon Hamas to combat the stigma faced by families of alleged collaborators. 69. Although it acknowledged that Hamas had already undertaken to support the families of persons accused of collaboration, the report concluded that the far-reaching effects of stigma call for a stronger response. 70. Was Hamas legally required to organize a collaborator pride parade? Israeli war crimes. The UN report divided allegations of Israeli war crimes into multiple, somewhat arbitrary, and frequently overlapping categories. If it had let the evidence speak for itself, the report would have compiled a devastating dossier on Israel's prosecution of protective etch. But it didn't. Instead, between its factual findings, on the one hand, and its conclusions, on the other, it interpolated contorted legal analyses. The report asserted that the factual conclusions formed the basis for the legal analysis of the individual incidents. 71. In reality, its legal analyses watered down the ghastly reality. The upshot of its intercession as interpreter and arbiter of the law was a dossier that, although it might not have satisfied Israel, except for a full-throat apologia, failed to meet the most exiguous standards of justice. In its parts and as a totality, the report was, simply put, a cover-up. In order to bring home this truth, there's no alternative except to juxtapose the facts presented in each incident, or group of incidents, with the report's tendentious legal interpretation of them. 1. Airstrikes. The UN report observed that as a result of Israeli airstrikes targeting residential and other buildings, at least 142 Palestinian families had 3 or more members killed in the same incident, for a total of 742 fatalities. 72 survivors of such attacks recalled, respectively, these scenes. I found the decapitated bodies of my uncle and daughter. My cousin was alive but died on the way to the hospital. Another cousin's body was found sliced in two. We had 10 corpses in the first ambulances. No other survivors were found. After having removed the cement, I identified my cousin Dina's body. What I witnessed was horrible. She was 9 months pregnant and she had come from her home to her parents' house to have her baby. We could not imagine that she had passed away. Her stomach was ripped open and the unborn baby was lying there with the skull shattered. We kept searching for other corpses and found my uncle's wife. We had great difficulty removing all the pieces of cement from her body. 73. I had a close look at the bodies. Only the upper part of my 9-year-old daughter's body was left. My son Mohammed had his intestines coming out. My 16-year-old cousin had lost his 2 legs. My son Mustafa, who was 5 meters away from me, had received shrapnel that almost completely severed his neck. My 16-year-old nephew lost both his legs and arms. He asked for my help. I just really wanted him to die quickly. I didn't want him to go through so much suffering. There was also my 1-year-old daughter who was in her mother's arms. We found her body on a tree. I myself lost my left arm. 74. The report was unable to find a possible military target in 6 of the 15 air assaults it investigated. 75 In one such lethal attack absent a military objective, a precision-guided 500-pound bomb targeted children on a roof, who had gone there to feed the birds, killing 3 of them and injuring 2 others. 76 The report's tabulation, which pointed to a possibly legitimate military target in 60%, 9/15, of the incidents, cast the Israeli attacks in a more favorable light than the established facts warranted. Consider the evidentiary basis of its calculations. The semi-official Israeli Intelligence and Terrorism Information Center, ITIC, posted the name, date, location, and combatant, terrorist operative, /civilian, non-involved, status of Gazans killed during protective edge. 77 If this Hasbara outfit listed a person killed during one of the Israeli airstrikes on a residential home as a terrorist operative, the report automatically denoted him a possible military target. 78 But setting aside its dubious determination of a victim's status, where and how did it get this information? ITIC never asserted that the building was targeted because of the terrorist operative's presence or, for that matter, that Israel was even aware of his presence when it attacked the building. In addition, the report itself observed that the presence of a Hamas member did not in itself transform the residence into a military object. The mere fact of being a member of the political wing of Hamas or any other organization in Gaza, or working for the authorities, is not sufficient in and of itself to render a person a legitimate military target. 79 Taking all these factors into account, it's possible that the Israeli airstrikes investigated by the report targeted combatants or military objects in only a small minority of cases. The UN report documented that in many of the incidents it chronicled, Israel launched the airstrike at a time of day when a large number of civilians was likely to be present. For example, the family was preparing for the iftar meal, the breaking of the fast at sunset. It was only a few minutes after they got up to have suhoor, the last meal of the day during Ramadan, until the breaking of the fast in the evening. All 12 members of the family were at home, preparing to break the Ramadan fast. The family had just finished a long meal in honor of the second day of the Eid, and most of the family members were taking a nap. They were gathered for iftar. 80 The report also found that Israel did not give warnings in at least 11 of the 15 incidents, while among some of the warnings that Israel did give, only a few minutes, between 3 and 5, elapsed between them and the actual attack. 81 The report additionally found that Israel used precision-guided missiles or precision-guided 500, 2,000-pound bombs in all 15 incidents. Here's how weapons experts described the impact of the GBU-31, which Israel used in several of the airstrikes investigated by the report. The explosion creates a shock wave exerting thousands of pounds of pressure per square inch psi. By comparison, a shock wave of 12 psi will knock a person down, and the injury threshold is 15 pounds psi. The pressure from the explosion of a device such as the Mark 84 JDAM-82 can rupture lungs, burst sinus cavities and tear off limbs hundreds of feet from the blast site, according to trauma physicians. When it hits, the JDAM generates an 8,500-degree fireball, gouges a 20-foot crater as it displaces 10,000 pounds of dirt and rock, and generates enough wind to knock down walls blocks away and hurl metal fragments a mile or more. There is a very great concussive effect. Damage to any human beings in the vicinity would be pretty nasty. 83. In regard to Israel's use of, inter alia, the GBU-31/Mk-84 2,000-pound bomb, the report concluded, regardless how precise the bomb is, it remains extremely questionable. Whether a weapon with such a wide impact area allows its operators to adequately distinguish between civilians and civilian objects and the military objective of the attack, when used in densely populated areas. 84. On this last point, recall that the report denoted Hamas's deployment of primitive rockets carrying 10 to 20 pounds of explosives inherently indiscriminate attacks because they cannot be directed at a specific military objective. It perplexes, then, why it's not also an inherently indiscriminate attack when Israel unloads, in a precision strike in the heart of a densely populated civilian neighborhood, a 2,000-pound bomb that generates an 8,500-degree Fahrenheit fireball, gouges a 20-foot crater as it displaces 10,000 pounds of dirt and rock and generates enough wind to knock down walls blocks away and hurl metal fragments a mile or more. Instead, the report deemed Israel's use of such a weapon in such circumstances extremely questionable. Pray tell, what questions remained? 85. The bigger point, however, is this: the UN report failed to adduce credible evidence that Israel mostly targeted military objectives in these airstrikes on civilian buildings. Even if in a handful of incidents Hamas militants were present, still, judging by the timing of the attacks, i.e., as large numbers of civilians predictably assembled, the paucity and inefficacy of the warnings issued, the use of high explosive precision weapons in densely populated civilian areas, and the wholesale destruction of civilian buildings that had already been abandoned. 86. Judging by the accumulation and compounding of these factors, the Israeli airstrikes constituted neither disproportionate attacks nor even indiscriminate attacks but, on the contrary, targeted attacks on Gaza's civilian population and infrastructure, in which the occasional presence of a Hamas militant was less a target than a pretext, the objective of these airstrikes almost certainly being, beyond the exaction of crude revenge, to terrorize the people of Gaza into submission by causing sufficient death and destruction as to break their will or turn them against Hamas. The report, however, did not reach this conclusion. It did find that the 6 targeted Israeli airstrikes where a military objective wasn't discernible, as well as most cases reported by non-governmental organizations, may constitute a direct attack against civilian objects or civilians, a war crime, while the other 9 incidents, where a possible military objective was discernible, could be disproportionate, and therefore amount to a war crime. 87. But although it did not recoil from speculating that Hamas fired rockets to spread terror, the report fell silent, despite an abundance of circumstantial evidence, on the possibility that Israel's overarching purpose in these airstrikes might have been to spread terror. It acknowledged that the attacks were carried out when it could be expected that most family members would be at home, in the evening or at dawn when families gathered for iftar and sahur, the Ramadan meals, or during the night when people were asleep. 88. And that large weapons apparently meant to raise buildings were used. 89. But it scrupulously avoided posing the question: why did Israel choose these times of day and these types of weapons? The report acknowledged that in the handful of instances where Israel did provide a few minutes' notice of an impending airstrike, by giving a warning, the IDF accepted that the attack did not require the element of surprise. Accordingly, there appears to be no reason why more time was not granted to the residents of the house to evacuate. 90. But it did not pose the obvious next question: why did Israel leave the occupants so little time to vacate their homes? The report acknowledged that regarding the destruction of high-rise buildings during the last week of Protective Edge, a statement by an IDF general seems to suggest that the objective of these strikes was to exercise pressure on the social elite of Gaza by destroying the high-rises. 91. But if it sought to exert political pressure on civilians via targeted airstrikes on civilian objects, wasn't Israel's goal to spread terror? The report acknowledged that an airstrike using precision weapons, which indicates that specific objectives were targeted, 92 killed children playing on a roof. It then went on to suggest that Israel may have breached its obligations to take all feasible measures to avoid or at least to minimize incidental harm to civilians. But wasn't the relevant point of law that Israel took all feasible measures to maximize harm to civilians, including children, that it targeted these children with precision weapons. The report observed that the massive scale of destruction and the number of homes and civilian buildings attacked raise concerns that Israel's interpretation of what constitutes a military objective is broader than the definition provided by international humanitarian law, and also raises concerns that these strikes may have constituted military tactics reflective of a broader policy that prioritized the perceived military objective over other considerations, disregarding the obligation to minimize effects on civilians. 93. It strenuously circumvented concerns that massive devastation was Israel's military objective, in order to maximize effects on civilians by terrorizing them, that its military tactics were reflective of this broader policy, and that its premeditated, pre-planned military tactics and military objective were not merely broader than the definition provided by but conceived in shocking willful breach of international humanitarian law. 2. Ground operations. The section of the UN report devoted to Israeli ground operations focused on IDF atrocities in Shuja'iyah, 19–20 July, Huzai, July 20 to August 1, Rafah, 1–3 August, and Shuja'iyah Market, July 30. It stated that the combined impact of these ground operations has had a devastating impact on the population of Gaza, both in terms of human suffering as well as in terms of damage to the infrastructure. At least 150 civilians were killed and more than 2,000 homes were completely destroyed. 94. The report scrutinized these operations individually and then presented a synoptic analysis of them. A. Shuja'iyah. Located near the Green Line, Shuja'iyah is among the most densely populated neighborhoods in Gaza. Although Israel issued warnings before the ground operation, most residents elected to stay put. On July 20, 13 IDF soldiers in Shuja'iyah were killed by Hamas militants in firefights. Israel then intensified its bombardment, ostensibly to rescue injured soldiers, at which point about half the residents fled. 95. The UN report noted that Israel fired 600 artillery shells into Shuja'iyah in less than an hour on July 20. The shelling continued for more than 6 hours, and dropped over 100 one-ton bombs in a short period of time. An IDF eyewitness testimony cited by the report recalled, "The Artillery Corps and the Air Force really cleaned that place up," while another testimony recalled, "One of the most senior officials in the IDF just marked off houses on an aerial photo of Shuja'iyah, to be taken down." By the operation's end, Shuja'iyah was a razed area, and likely leveled as a result of focused IDF demolitions efforts. Fully 1,300 buildings were completely destroyed or seriously damaged, and many civilians were killed or injured. 96. The report's legal analysis found that the methods and means employed by the IDF in Shuja'iyah raise questions and raise serious concerns as to its respect for the laws of war. Distinction. The overwhelming firepower could not, in such a small and densely populated area, be directed at a specific military target, and also violated the prohibition of treating several distinct individual military objectives in a densely populated area as one single military objective. Therefore, strong indications exist that the operation was conducted in violation of the prohibition of indiscriminate attacks and may amount to a war crime. Feasible precautions. It is questionable whether the use of such immense firepower in such a short period would have allowed the IDF to respect its obligation to do everything feasible to verify that the targets were military objectives, while the fact that the IDF persisted in this intensive shelling long after it must have known of the dire impact on civilians and civilian objects evidences the commander's failure to comply with his obligation to do everything feasible to suspend an attack if it becomes apparent that it does not conform to the principle of proportionality, and proportionality. The objective of the shelling and heavy bombardment appears mainly to have been force protection. Given the means and methods used by the IDF in Shuja'iyah, it is possible to conclude that a reasonable commander would be aware of the potential for such an intense attack to result in the death of a high number of civilians. As such, it is highly likely that a reasonable commander would therefore conclude that the expected incidental loss to civilian life and damage and destruction of civilian objects would be excessive in relation to the anticipated military advantage of this attack. 97. Before assessing the report's legal findings, it's useful to take a step back. After enduring an unusual number of IDF casualties, Israel fired probably thousands of high-explosive artillery shells and dropped scores of one-ton bombs on Shuja'iyah. Israel alleged that it deployed such massive firepower in order to rescue injured combatants. 98 The report didn't even try to demonstrate a logical nexus between such massive indiscriminate force, on the one hand, and a rescue operation, on the other. Instead, it faithfully echoed Israeli Hasbara. The objective of the shelling and heavy bombardment appears mainly to have been force protection. How on earth does one rescue injured soldiers by firing with abandon thousands of indiscriminate artillery shells and dropping scores of one-ton bombs in a densely populated civilian neighborhood? How does one rescue injured soldiers by methodically demolishing hundreds upon hundreds of civilian homes? The report noted that Hamas accused the IDF of taking revenge on the civilian population for its military defeat in the battleground. 99 But it brushed aside this explanation, although, prima facie, it's surely the more plausible one. Indeed, IDF testimonies themselves recalled the targeting of random civilian homes in revenge after a soldier's death. 100 The report stated that the IDF may have committed indiscriminate attacks. But in dropping one-ton bombs on, and firing high-explosive artillery shells into, a densely populated civilian neighborhood absent a credible military objective, didn't the IDF conduct discriminate attacks on civilians? Was the essence of Israel's crime that it treated several distinct individual military objectives as one single military objective, or that it treated the entire civilian population and infrastructure as its military objective? The report faulted Israel for not doing everything feasible to verify that the targets were military objectives, and persisting in the operation long after it must have been aware of its dire impact on civilians. But wasn't the manifest purpose of the operation to target, not military objectives, but civilians and civilian objects? Didn't Israel persist not despite but because of the operation's dire impact on the civilian population? The report stated that Israel didn't properly balance incidental loss of civilian life and destruction of civilian objects against military advantage. But what military advantage could Israel possibly have reaped by deploying such massive firepower in a densely populated civilian neighborhood? How could the devastation have been incidental to the operation when it was its very essence? The report observed that in spite of the significant destruction and credible allegations of civilian casualties in Shuja'iyah, there wasn't any ongoing investigation into the events by Israel. 101 But if the operation's objective was to inflict significant civilian death and destruction, wouldn't such an investigation be superfluous? Instead of illuminating, via the idiom of law, the nature of Israel's crimes in Shuja'iyah, the report occluded them, the crux of its legal analysis, that is, that Israel was pursuing a military objective and was seeking a military advantage was a whitewash and a sham. It also cannot but bewilder that whereas the report expressed certainty that Hamas's executions of alleged collaborators amount to a war crime, Israel's saturation bombing of a densely populated civilian neighborhood may amount to a war crime. B. Huzai. On July 21, the village of Huzai, located near the Israeli border, came under Israeli air assault, and on July 22 the IDF physically isolated it from the outside world, fragmented it internally, cut off the electricity, and shot up the water supply. The village then came under intense fire from the air and the ground. The report stated that Huzai became a zone of active fighting and everything in it was turned into a target. But it's unclear why the report used the phrase zone of active fighting, neither it nor other sources 102 documented any firefights or IDF casualties. By the operation's end, some 70 Gazans, including at least 14 civilians, were dead and 740 buildings were damaged or destroyed. 103 The report homed in on several incidents during the assault on Huzai. Among them, civilians holding a white flag and attempting to leave Huzai were confronted by a group of IDF soldiers who opened fire on them. 11 people were seriously injured. Huzai's only clinic was struck by repeated Israeli airstrikes. An ambulance found a 6-year-old boy who was critically injured. He was taken to an IDF checkpoint in order to be transferred to the closest ambulance. The ambulance was kept waiting for at least 20 minutes in spite of the evident seriousness of the victim's injuries and his being a child. The boy died. A family fled in a state of complete panic, leaving behind one of the family members, a woman aged about 70, in a wheelchair. When a family member returned home a few days later, he found her dead body. She had a bullet mark in her head and blood on her face. The doctor who later examined the body stated that she had been shot from close range, from a distance of about 2 meters. Days or weeks later, an Israeli soldier posted on Twitter a picture of another IDF soldier offering water to her. 104 The Union report's legal analysis found that the intensity of the shelling, which decimated Huzai's civilian infrastructure, and the bulldozing of buildings throughout the ground operation, raise concerns that the IDF shelling and airstrikes were not exclusively directed at military objectives, that it appears highly unlikely that the 740 buildings either destroyed or damaged all made an effective contribution to military action, and that the complete razing of some areas of Huzai indicates that the IDF may have treated several distinct individual military objectives in a densely populated area as one single military objective, and also indicates that the IDF carried out destructions that were not required by military necessity. The report concluded that strong indications exist that these elements of the IDF assault on Huzai may qualify as direct attacks against civilians or civilian objects and may thus amount to a war crime. 105 It went on to find that by refusing to allow civilians to flee, despite the intense shelling and aerial bombardment and full knowledge of their presence, the IDF very likely committed indiscriminate or disproportional attacks, and it also raises concern that not all feasible precautions to minimize danger to civilians were taken by the IDF in its attack against the town of Huzai. 106 It additionally observed the extent of the destruction combined with the statements made during the operation by the commander of the brigade responsible for the Huzai operation to the effect that Palestinians have to understand that this does not pay off, are indicative of a punitive intent and may constitute collective punishment. 107 The report's legal analysis was as revealing in what it did not say as in what it did say. It registered concern that Israel's massive shelling and airstrikes, which leveled Huzai's civilian infrastructure, were not exclusively directed at military objectives. But although it didn't identify a single firefight or IDF casualty, and although it didn't identify a single military objective, the report never broached the possibility that Israel's firepower overwhelmingly targeted civilians and civilian objects. The report deemed it highly unlikely that Israel's systematic demolition of civilian buildings made an effective contribution to military action. But even as it concluded that the devastation may qualify as direct attacks against civilians and civilian objects, it steered clear of the possibility that if Israel was engaged in a military action, its military objective was to destroy civilian buildings. It posited the scenario that by effacing parts of Huzai from the map, the IDF may have treated several distinct individual military objectives in a densely populated area as one single military objective, and may have carried out destructions that were not required by military necessity. But it didn't consider the possibility that Israel's objective was not military but wholly civilian. While military necessity didn't even figure as an element in its calculation, how could it in the absence of a military objective? The report reckoned it very likely that trapping civilians in a village and then bombarding it constitutes an indiscriminate and disproportionate attack. It would appear to be even more likely that it constituted a targeted attack on civilians. especially as the report didn't identify any fighting, military objective, IDF casualties, or military value against which to weigh the loss of civilian life. The report did acknowledge, in a single paragraph, that the impetus behind the operation may also have included a punitive element and therefore constituted collective punishment. But the death and destruction Israel visited on Huzai were not merely incidental to, or a subordinate component of, an otherwise military operation, they were the natural and foreseeable result, that is, the intention 108 of an operation that primarily targeted, and was primarily designed to punish and terrorize, the civilian population. See Rafah. 109 After Hamas killed 2 IDF combatants in Rafah and apparently captured a third soldier alive, Israel launched a major military operation, Black Friday, on August 1. The report stated that the IDF sealed off Rafah, fired over 1,000 shells against Rafah within 3 hours and dropped at least 40 bombs, launched intense attacks against inhabitants in their homes and in the streets, fired on ambulances and private vehicles trying to evacuate civilians, and demolished dozens of homes. The ferocity of Black Friday traced back to Israel's dread of a replay of the Gilad Shalit Affair 110, in which Hamas's capture of an IDF soldier eventually led to the release of more than 1,000 Palestinian detainees in a prisoner exchange. The report focused on several egregious incidents, for example, a hospital that was struck by 2 missiles and dozens of shells. It quoted leaked audio recordings of IDF radio communications indicating Israel's unrestrained use of firepower, and concluded that virtually every person or building in Rafah became a potential military target. 111 The report's legal analysis stated that information of attacks on all vehicles in the area, including ambulances, as well as incidents in which groups of civilians appear to have been targeted by tank fire, raises serious concerns as to the respect by the IDF of the principle of distinction. This amounts to a deliberate attack against civilians and civilian objects and may amount to a war crime. It went on to state that in light of the massive, unrestrained use of firepower in a densely populated and built-up area over the period of a few hours, the assault appears to have violated the prohibition of indiscriminate attacks. Of the massacres profiled in the report, Rafah was the only instance in which Israel appeared to have an identifiable quasi-military objective, that is, to kill the captured Israeli soldiers so as to preempt a future prisoner exchange, although, as the report made clear, this objective could not legitimize what ensued. 112 The report stated unequivocally that Israel's attacks on all vehicles and its targeting of groups of citizens amount to a deliberate attack against civilians and civilian objects. But it then inserted the caveat, and may amount to a war crime, emphasis added. Even as the report dared utter the unutterable that Israel targeted civilians, it recoiled at the legal complement. How can a deliberate attack against civilians and civilian objects not be a war crime? D. Shuja'iyya Market. On July 30, Israel announced a 4-hour unilateral truce, but it qualified that the ceasefire would not apply to the areas in which IDF soldiers are currently operating. The report homed in on a bloody sequence of incidents in a Shuja'iyya neighborhood. The roof of a home was hit by high-explosive mortar shells that killed 8 family members, including 7 children aged between 3 and 9, who were playing there, and their grandfather aged 70. Israel purported that the attack was in response to an anti-tank missile and a burst of mortar fired from the neighborhood that injured 1 soldier. The IDF then fired another round of shells 10 minutes later, just as 3 ambulances and the paramedics arrived at the scene, which also hit many of the people who had gathered around the family house to try and help survivors. The report cited a journalist eyewitness who was stunned by the apparent targeting of ambulances and journalists who had rushed to provide assistance to the injured and cover the incident. It further noted that eyewitness accounts are corroborated by 2 video recordings, one of which showed a dying cameraman continuing to film, and the ambulances being hit by a rocket. The report found, as a result of the second round of shelling, 23 persons were killed, including 3 journalists, 1 paramedic, and 2 firemen. In addition, 178 others were injured, among them 33 children, 14 women, 1 journalist, and 1 paramedic. 4 are reported to have died as a result of the injuries they sustained in this attack. Although Israel subsequently alleged that it did not have real-time surveillance of the lethal assault, the report didn't buy this alibi. The Commission finds it hard to believe that the IDF had no knowledge of the presence of ambulances in the area in the aftermath of the initial strike, especially when the rescue crews, a fire truck, and 3 ambulances arrived at the scene with sirens blazing loudly. 113 The report's legal analysis faulted Israel for using indiscriminate mortars in a built-up, densely populated area. It consequently found that the attack may have violated the prohibition of indiscriminate attacks, and the obligation to take all feasible precautions to choose means to spare civilians. 114 Try as one may, it is most difficult to make sense of this legal analysis. For argument's sake, let it be granted that the 7 children playing on the rooftop and their 70-year-old grandfather were killed in an indiscriminate attack, although as the report itself and previous human rights reports 115 documented, this wouldn't have been the first time that Israel targeted children playing on a roof. But what about the second attack 10 minutes later? The assault began just as neighbors, ambulances, rescue crews, and a fire truck arrived at the family's home. A journalist testified to the targeting of ambulances and journalists, emphasis added, while a video recording captured ambulances being hit by a rocket. The report itself dismissed the possibility that Israel was unaware of the bloodbath, especially when the rescue crews, a fire truck, and 3 ambulances arrived at the scene with sirens blazing loudly. To classify this focused artillery and rocket barrage on a civilian medical rescue operation, absent any discernible military objective, as an indiscriminate attack in which Israel didn't take sufficient precautions to protect civilians, with the afterthought that it may qualify as a direct attack against civilians, and not as a clear-cut targeted attack directed at civilians, makes mockery of language, law, and human suffering. The UN report also undertook a synoptic analysis of protective edges ground operations under several heads. 1. Protection of civilians, force protection. The report found that Israel prioritized the safety of its combatants over humanitarian concern for Gaza's civilian population. The protection of IDF soldiers was a major consideration for the IDF, overruling and, at times eliminating, any concern for the impact of its conduct on civilians. When soldiers' lives were at stake or there was a risk of capture, the IDF disregarded basic principles of the laws of war. 116, 2. Warning and the continued protected status of civilians. The report found that Israeli warnings yielded equivocal results. The IDF sought to warn the population in advance by means of leaflets, loudspeaker announcements, telephone and text messages and radio broadcasts, which led to the successful evacuation of some areas. While these general warnings appear to have saved the lives of many people who heeded them, in other cases, inhabitants did not leave home for a number of reasons. On the last point, the report observed that Gaza lacks secure places of refuge where civilians could flee. 44% is either a no-go area or has been the object of evacuation warnings, that ALL areas in Gaza, including those towards which the population was directed, had been or were likely to be hit by airstrikes, and that the generalized and often unspecific warnings sometimes resulted in panic and mass displacement. Indeed, the spokesperson for the major refugee relief organization in Gaza, Chris Gunness of the United Nations Relief and Works Agency, UNRWA, painfully reflected in the midst of the Israeli assault, Gaza is a conflict with a fence around it. It is unique in the annals of contemporary warfare. There's nowhere safe to run and now there's nowhere safe to hide. The report further observed that, on the one hand, the effective rules of engagement treated civilians who stayed put as enemy combatants, even though the IDF should have been well aware that civilians had remained behind, and that, on the other hand, the prior alerts could be construed as an attempt to use warnings to justify attacks against individual civilians who didn't flee. 117, 3. Use of artillery and other explosive weapons in built-up areas. The report found that Israel made significant use of explosive weapons with wide area effects in densely populated areas, which resulted in a large number of civilian casualties and widespread destruction of civilian objects. It further noted that Israel persisted in its use of such indiscriminate weapons in densely populated civilian areas even after they resulted in significant civilian casualties. 118, 4. Destruction. The report found that the firepower used in Shuja'iyah, Rafah, and Huzai resulted in significant destruction. Some areas were virtually razed, completely obliterated. It also quoted Israeli soldiers testifying that every house we passed on our way into the Gaza Strip got hit by a shell and houses farther away too. It was methodical, and the damage to Palestinian property was not a consideration when determining the scope and force of fire. The report went on to say that the vast scale of destruction may have been adopted as tactics of war, that the IDF followed a pre-calculated pattern of widespread razing of neighborhoods in certain areas, and that this razing of entire areas may not have been strictly required by military necessity. 119 and 5. Targeting of civilians. In a brief treatment, just one paragraph, the report noted a number of cases in which civilians, who were clearly not participating in the hostilities, appear to have been attacked in the street. It pointed to a couple of incidents in which civilians, including children, allegedly carrying white flags were fired upon by soldiers, and a third incident, in which a wounded man, lying on the ground, was shot again 2 times and killed. 120. The report found that Israel deliberately killed just 2 civilians during the whole of the ground operation. In essence, the picture presented by the UN report looks something like this. Israel launched Protective Edge in order to achieve a pair of unimpeachable military objectives: end Hamas's projectile attacks, dismantle Hamas's tunnel network. In the course of the assault, it resorted to indiscriminate and disproportionate force primarily because it attached a higher priority to the lives of its own combatants than to Gaza's civilian population. Still, on the one hand, Israel did issue warnings that, although not always effective, saved the lives of many people. The report didn't provide a basis for this calculation. 121. And, on the other hand, although many civilians were injured and killed, Israel intentionally targeted only a handful of them. Put simply, Protective Edge was a legitimate military operation that, alas, often went awry but only exceptionally crossed the red line of targeting Gaza's civilian infrastructure, and next to never crossed the red line of targeting its civilian population. The report's overarching conceit could not, however, accommodate many of its own findings and conclusions. If the warnings were designed to save lives, why were so few issued? Why was so little advance notice given when they were issued, and why were so many of them, such as the roof knock, ineffective by the report's own account? 122. If the areas toward which Israel directed the civilian population were likely to be hit by airstrikes, then those fleeing after an alert found safe haven more as a result of serendipity than anything else. In fact, Israel almost certainly issued these warnings in order to embroider its Hasbara campaign, and to provide itself with legal cover in the event of post-war prosecutions, or in the report's own words, to justify attacks against individual civilians who didn't flee after the alerts. They also served to foment panic and mass displacement, which the report depicted as collateral effects, but which, to judge by prior Israeli operations, were a premeditated objective. 123. The denouement of Protective Edge provided the most compelling proof that, overwhelmingly, Israeli warnings were contrived, not to save lives but with these other goals in mind. Although it had been forced to terminate the ground invasion in early August after international outrage peaked, Israel still sought to gain leverage in the ongoing negotiations by launching airstrikes, in late August, on 4 high-rise buildings occupied by Gaza's social elite. 124. However, fearful of evoking renewed condemnation, Israel was at pains not to kill civilians, particularly influential civilians, so it issued effective warnings that enabled all the building's residents to evacuate safely. 125. The fact that no Gazans died in these airstrikes pointed up that if Israel were so inclined, it could have issued truly effective warnings. The report praised these late August warnings as a good practice, through which Israel attempted to minimize civilian casualties. 126. Wasn't it a tad unseemly to congratulate Israel on its good practice to minimize civilian casualties when, in this last scene of the last act of a terror assault on a defenseless civilian population that had already left more than 1,000 civilians dead and tens of thousands homeless, Israel proceeded to level yet more homes, in particular as this good practice was proof positive that except when it was politically advantageous, Israel issued warnings only to grease its PR machine and sow panic, not to save lives, while Israel's primordial objective, made manifest by its use of one-ton bombs in densely populated civilian neighborhoods, was so far as diplomatic constraints would allow it to maximize civilian casualties. If, as the report inferred, the principal impetus behind Israel's resort to indiscriminate and disproportionate force was to protect its combatants, that might explain why it adopted a criminal shoot-to-kill-anything-that-moves policy in areas where ground troops were operating. But why did Israel indiscriminately fire from afar tens of thousands of indiscriminate high-explosive artillery shells into densely populated civilian neighborhoods, which resulted in a large number of civilian casualties and widespread destruction of civilian objects, and why did it persist in its use of such indiscriminate, high-explosive weapons in densely populated civilian areas even after it was clear that they resulted in significant civilian casualties? Why did it drop hundreds of one-ton bombs over densely populated civilian neighborhoods? Why did it raze to the ground and obliterate entire civilian neighborhoods, in the total absence, as IDF eyewitness accounts repeatedly attested, of military activity? The report did acknowledge that Israel perhaps inflicted this pre-calculated devastation as tactics of war that weren't strictly required by military necessity. It was, to be sure, an odd way to describe a destruction process in which, overwhelmingly, neither military necessity nor for that matter military considerations of any kind figured as even a factor. The report didn't pose, let alone answer, the question begging to be asked. If not from military necessity, then why did Israel, in a pre-calculated fashion, adopt tactics of war that wreaked massive death and destruction in Gaza? In fact, if safeguarding the lives of Israeli combatants at any cost was the modus operandi of Protective Edge, then punishing and terrorizing the civilian population into submission was its overarching objective. The report itself copiously documented that Israel fired tens of thousands of high-explosive artillery shells into, and dropped hundreds of one-ton bombs over, densely populated civilian neighborhoods, targeted hospitals, ambulances, rescue teams, civilian vehicles, and groups of citizens, and pursued a shoot-to-kill-anything-that-moves policy in pacified areas that still contained civilians. But nonetheless it was the finding of this cynical, craven document that of the 1,600 Gazan civilians killed by Israel during the 51-day terror onslaught, only 2 were killed deliberately. The UN report included a miscellany section that analyzed Israeli attacks on 1. Civilian shelters, 2. Gaza's only power plant, and 3. Ambulances. 1. Civilian shelters. The UN report noted that Israel attacked multiple civilian shelters, and it investigated the attacks on 3 of them: Beit Hanoun Co-Educational A and D School, Beit Hanoun School, Jabalaya Elementary Girls A and B School, Jabalaya School, and Rafah Preparatory Boys A School, Rafah School, that resulted in the deaths of some 45 persons, including 14 children. Beit Hanoun School. The report stated that UNRWA was in regular contact with Israeli officials, had given them the school's coordinates on 12 occasions, and had informed them that the school was being used as a designated emergency shelter. It further stated that Beit Hanoun was witness at the time of the incident to heavy fighting, including daily shelling in the vicinity of the school. As the fighting intensified, the shelter's occupants were persuaded to leave, and a time slot for their evacuation was synchronized between the IDF and UNRWA. An IDF commander subsequently conveyed his intention to target other schools in the area, allegedly because a Hamas arsenal was hidden among them, but had reconfirmed at least twice that the designated emergency shelter would not be targeted. However, as families gathered their belongings and assembled in the school courtyard on July 24 to await bus transportation, the building was suddenly attacked by at least two 120 mm high explosive, mortar projectiles. One hitting the middle of the schoolyard and a second the steps in front of the school's entrance. Israel variously alleged that Hamas prevented the shelter's occupants from leaving at the assigned time, that the attacks had been caused by Hamas rockets misfiring, and that soldiers returned fire at locations from which Palestinian missiles had been fired at them. The report found no evidence supporting these official Israeli alibis. On the contrary, it noted that witnesses consistently affirmed that there had been no rocket fire from the school, nor militants operating in its vicinity, nor any suspicious activity. The report concluded, the fact that the attack occurred before implementation of an evacuation agreement indicates that the advance warning communicated to UNRWA by the IDF was not effective. 127. Jabalia School. The report stated that prior to July 30, Israeli agencies were notified 28 times in 14 days about the site's use as an UNRWA shelter, and that Israel had confirmed receipt of this information. In addition, UNRWA was in steady contact with the relevant Israeli agencies by email and telephone. But on July 30, without advance warning, the school was hit by a barrage of four 155 mm high explosive, projectiles, an artillery indirect fire weapon. 18 people were killed, including 3 children. The IDF alleged that Hamas had fired at Israeli armed forces from the vicinity of the school. The report, however, found no evidence corroborating the Israeli allegation. 128. Rafah School. The report stated that on August 3 a precision-guided missile hit the street in front of the school, killing 15 people, including at least 7 children. Israel alleged that the IDF had fired an aerial-launched missile at a motorcycle, which had been carrying 3 militants from Palestinian Islamic Jihad. The report didn't adduce evidence either supporting or belying the official Israeli version of what happened. 129. A subsequent investigation by the Al-Mazan Center for Human Rights found that 2, not 3, Gazans were riding the motorcycle, and both were civilians. 130. The UN report's legal analysis of the first 2 incidents, Beit Hanoun and Jabalia, 131 stated that Israel must have been aware that by deploying relatively indiscriminate weapons, such as artillery or mortars, to strike a target located in a densely populated area and adjacent to UNRWA schools used as a shelter, it might also hit civilian objects. It went on to express serious concerns that Israel's choice of means for the attack did not take into account the requirement to avoid incidental loss of civilian life. Did not take all feasible precautions to choose means with a view to avoiding casualties. Hence, these assaults are highly likely to constitute an indiscriminate attack, and may amount to a war crime. The explicit premise underlying the report's legal analysis was that Israel targeted military objects in these attacks. But the report didn't adduce a jot of evidence to sustain this premise. On the contrary, the mass of evidence assembled by it dictated the conclusion that Israel intentionally targeted civilians taking shelter. The report's own factual summary, in the Beit Hanoun incident, pinpointed that the attack occurred not during an exchange of fire but before implementation of an evacuation agreement. How else is one to interpret this contextualization except that the assault was timed with, or geared to, the scheduled evacuation, and that the object of the attack was the shelter grounds? The undisputed facts that an agreement had been reached with the IDF for a peaceful, orderly exodus, and that the IDF commander twice expressly promised not to target this particular shelter, compounded the crime as an appalling act of perfidy. The report's contention that these incidents constituted indiscriminate attacks flew in the face of its own factual findings, while its depiction of the ensuing civilian deaths as incidental begs the question: incidental to what? The report didn't point to a military objective in either incident while, as it itself documented, Israel's official story kept shifting as each of its successive alibis kept unraveling. The report reckoned it a critical finding of fact that Israel's advance warning was not effective, even though the warning proved to be a most effective instrument of criminal perfidy, while the report reckoned it a critical finding of law that Israel did not take all feasible precautions to protect civilians, even though it did take all feasible precautions to set them up for a bloodbath. It was as if the report were playing a Victorian parlor game. Who can contrive the most absurd factual or legal description of a manifestly criminal act? In another contrived iteration, the report stated that whereas Israel relied on its civilian agencies to facilitate communication between international organizations and the Israeli military, and there seemed to have been attempts to notify UNRWA about possible attacks in the case of Beit Hanoun, the incident suggests that communication between UNRWA and the IDF was not effective. But the report itself documented that even though the IDF coordinated the evacuation with UNRWA, and even though the IDF commander made repeated, explicit promises not to target the shelter, the IDF launched an attack on the shelter grounds just before the agreed-upon time slot while families started gathering their belongings in the courtyard so as to be ready when the buses arrived. The upshot was not a communications breakdown but criminal bad faith. Indeed, not even Israel in its various official justifications blamed the attack on a lapse in communications. The report created this alibi out of whole cloth. The report's legal analysis additionally observed, even though the attack against the UNRWA schools may not have been deliberate, the IDF is bound by the obligation of precautionary measures and verification of targets to avoid attacks directed by negligence at civilians or civilian objects. The choice of phraseology, even though the attack may not have been deliberate, was twice over peculiar. On the one hand, the report's legal findings never even hinted that the attacks were deliberate. To the contrary, it studiously avoided this conclusion while, on the other hand, the factual evidence assembled in the report left little doubt that they in fact were deliberate. The report also considered it a relevant legal point that Israel didn't take sufficient precautions to avoid attacks directed by negligence at civilians or civilian objects, whereas it was hard not to conclude from the report's own rehearsal of the factual record that Israel, far from being negligent, took every precaution and acted with full premeditation to target civilians and civilian objects. 132 Even ever cautious UN Secretary-General Ban Ki-moon finally blurted out after the Israeli attack on Rafah school, the 7th civilian shelter to be targeted, that it was a moral outrage and criminal act. 133. 2. Gaza's only power plant. The UN report noted that Israel's repeated shelling of the only power plant in Gaza at the end of July caused severe damage. The last shelling on July 29 caused one of the plant's fuel tanks to explode, which eventually destroyed almost an entire section of the plant and damaged other parts. It also noted that as a result of that attack, and of damage to the electricity infrastructure more generally, Gaza experienced power outages of 22 hours a day during the hostilities, which forced hospitals to operate at limited capacity, led to a drastic reduction in the pumping of water to households, and affected desalination plants and sewage treatment. A year later, Israel purported that its shells had unfortunately missed their intended target. Although the report pleaded agnosticism, the Commission is unable to verify this account. It also observed that Israel had already hit the power plant back in 2006 as well as during Operation Cast Lead, that at the inception of Protective Edge, a senior Israeli official had called on the government immediately to cut off fuel and electricity supplies to the Gaza Strip, and also exhorted the government to use all of the levers of pressure at its disposal in order to coerce Hamas to accept a ceasefire, and that the plant had been hit 3 times in the days just prior to the climactic July 29 strike. The report's legal analysis reiterated that owing to the limited evidence available, it is unable to determine whether the power plant suffered incidental damage from an attack directed elsewhere, or whether it was the object of a deliberate attack. Still, it went on to speculate, if the strike against the power plant was accidental, as Israel claims, there remain nonetheless questions as to whether all appropriate precautions were taken by the IDF to avoid damage to a civilian object. 134 Noticeably, it didn't ponder the possibility that the attack was deliberate, and the attendant legal consequences if it was. But the larger point is this: the report's avowed legal mandate was not to reach a definitive determination but instead to use a less stringent reasonable ground standard in its assessment of incidents investigated and patterns found to have occurred, that is, what a reasonable and ordinarily prudent person would have reason to believe happened. It appears a safe bet that a reasonable and ordinarily prudent person would have concluded something along these lines. In light of the pattern of targeted Israeli attacks on the power plant in previous years. 135. And multiple shellings of the plant in the days preceding the July 29 attack, and in light of the minatory statements by a senior Israeli official before the attack, and in light of the fact that the only counter-evidence consisted of boilerplate Israeli denial that has rarely withstood scrutiny in the past, in light of this compelling and cumulative circumstantial evidence, the attack on Gaza's only power plant, which exacerbated its already dire shortage of electricity, was most likely deliberate and amounted to a war crime. If the report didn't reach this conclusion, that's because it construed the better part of prudence to be pusillanimity. 3. Ambulances. The UN report noted that protective edge resulted in damage to 16 ambulances and the death of 23 health personnel. It focused on a trio of incidents that it had already dissected, in Shuja'iyya Market, and Rafah, and on a pair of cognate incidents in Al-Qarara village and Beit Hanoun, in which ambulances came under Israeli attack and 35 medical personnel and other civilians were killed and many more injured. It presented a condensed version of the first 3 incidents and a more detailed account of the 2 others. Shuja'iyya. A military medical aid ambulance was directly hit twice while attempting to provide first aid to victims. Shuja'iyya Market. In a context of intense fire, a shell struck the ground close to 3 ambulances in the proximity of a house that had been attacked. Rafah. 8 people burned to death in an ambulance that was hit. Al-Qarara. Mohammed Hassan Al-Abdallah, an ambulance driver, came under fire while evacuating an injured person. When Al-Abdallah's ambulance arrived at the location, the IDF instructed the crew to exit the vehicle and continue on foot. Mohammed Hassan Al-Abdallah and one of 2 volunteers got out of the ambulance and approached the patient with a flashlight on, as directed. They had walked about 12 meters when they came under fire and Mohammed Hassan Al-Abdallah was hit in the chest and thigh. 2 ambulance teams that arrived a little later to rescue their wounded colleague also came under fire, despite earlier ICRC International Committee of the Red Cross information that the IDF had approved their entry to the area. A 3rd team was finally allowed to take Al-Abdallah to Nasser Hospital in Khan Yunis, where he died shortly upon arrival. The ambulance's movements were at all times coordinated with the IDF through the ICRC. Beit Hanoun. A missile appears to have hit the back of a PRCS Palestine Red Crescent Society ambulance during a rescue operation in Beit Hanoun. As a result, an ambulance volunteer was killed and 2 other rescuers inside the ambulance were injured. When another ambulance team was dispatched to respond, a missile hit the rear part of this vehicle, which caught fire. The ambulance had its siren and flashing red light on and, at the time of the strike, the street was deserted. The report did not discover in any of the 5 incidents any information, or receive any allegations indicating that the ambulances involved were used for a purpose other than their humanitarian function. It went on to observe that reports of repeated strikes on ambulances that came to the rescue of injured staff suggest that the ambulances and personnel may have been specifically targeted, that many, if not most, of the reported strikes on ambulances appear to have occurred without there having been any obvious threat or military activity in the area, and that ambulances were marked with emblems, health workers wore uniforms, and the IDF had been notified repeatedly of their movements. The report's legal analysis found that some of the incidents constitute a violation by the IDF of the prohibition of attacks on medical transports and medical personnel, and may amount to war crimes, in particular, if the vehicles or personnel attacked used the distinctive emblems of the Geneva Conventions. 136 Although they appear reasonable, at any rate by the dismally low standards set by the report, one can still quarrel at points with this factual presentation and legal finding. It stated that ambulances in Shuja'iyya market came under attack in a context of intense fire. But if none of the witnesses reported return fire by Palestinians, shouldn't it have said, in a context of intense fire by Israel? It stated that some of the incidents violated the laws of war. Which of the 5 shocking incidents, it might be wondered, didn't? If the report unequivocally found that Hamas's executions of alleged collaborators amount to a war crime, it might also be wondered why, even though the report compiled a mass as well as a pattern of damning evidence, it could find only that Israel's repeated targeting of clearly marked ambulances in the absence of any military justification may amount to a war crime. If the report could exhort that whoever is responsible for the executions of alleged collaborators in Gaza must be brought to justice, it might also be wondered why it wasn't equally emphatic that whoever was responsible for the targeting of medical personnel and rescue crews must be brought to justice. The report's legal findings stated that Israel may have committed a war crime because it violated the prohibition against attacks on medical transports and personnel. But wouldn't it also be a war crime if they weren't medics but simply civilians? This prompts the most perplexing and serious question of all. The report found convincing evidence that Israel specifically targeted these medical personnel/civilians absent any military rationale and in the full knowledge of their non-combatant status. It tallied 35 deaths as a result of the 5 ambulance attacks it investigated. But why then did the report calculate under its rubric targeting of civilians that Israel had committed only 2 targeted killings of civilians during protective etch? Indeed, Israel's targeting of ambulances, medical personnel, and rescue crews absent a discernible military objective itself did not deviate from, but merely shone a brighter light on, the actual strategic goal of protective etch, to punish, humiliate, and terrorize Gaza's civilian population, part and parcel of which was the infliction of massive civilian casualties. Finally, a glaring omission in the UN report's inventory of Israeli war crimes warrants notice. Israel destroyed 70 mosques and damaged 130 more during protective etch. It is a war crime under international law to target places of worship which constitute the cultural or spiritual heritage of people. 137 The report made precisely 4 passing allusions to attacks on Gaza's mosques, of which 3 repeat Israeli Hasbara. That Hamas hid weapons inside or fired from them, and 1 is a sentence fragment that a mosque had been hit. 138 The report devoted many paragraphs to the psychic distress Israelis suffered during protective etch, but it had not a single word to say about the psychic impact in a deeply religious society of Israel's assault on Gaza's mosques. If Hamas had destroyed scores of Israeli synagogues, is it conceivable that the report would have ignored it? The issue isn't whether or not Israel deliberately targeted Gaza's mosques without military justification, although the available evidence overwhelmingly suggests that it did. 139 The telling point is this: the report didn't deem the mass destruction of mosques worthy of attention, let alone investigation. The UN report's penultimate chapter analyzed steps taken by each party to hold accountable violators of the laws of war during protective etch. The section on Palestine, consisting of 9 paragraphs, essentially pleaded that little information was available, and then concluded that Palestinian authorities have consistently failed to ensure that perpetrators of violations of the laws of war are brought to justice. 140 The heart of this chapter, running to fully 45 paragraphs, parsed Israel's judicial response. 141 The sheer amount of space devoted by the report to this undertaking conveyed the impression that Israel's system of legal accountability was a worthy object of investigation. The facts, however, reveal that this system is a farce. The UN report observed that Israel has in the past failed to hold accountable those responsible for alleged grave violations of the laws of war. For example, during Cast Lead, 1,400 Gazans were killed, up to 1,200 of them civilians, while much of Gaza's civilian infrastructure was laid waste. But only 4 Israelis were convicted of wrongdoing, and only 3 of them were sentenced to jail. The maximum sentence was 7.5 months for theft of a Palestinian's credit card. 142. The report further noted that Israel hadn't launched a single criminal investigation regarding Operation Pillar of Defense, 2012. It concluded that the track record of Israel's judicial system raises serious questions regarding the effectiveness of the current mechanisms to hold to account those responsible for the most serious alleged crimes. It then went on to observe that the picture is equally bleak when reviewing other data, whether they pertain to the many killings of Palestinians in the West Bank, only 2 indictments and 1 conviction, or the many allegations of torture and ill treatment of Palestinians. Not a single criminal investigation was opened. Still, the report espied a silver lining in the cloud. It purported that Israel has in recent years significantly upgraded its system of legal accountability. In 2010, Israeli commandos launched an assault on the Gaza Freedom Flotilla, killing 9 passengers aboard the flagship Mavi Marmara. 143. The international outrage after these deaths compelled Israel to appoint an investigative commission chaired by former Supreme Court Justice Jacob Turkel. The findings of the Turkel Commission comprise 2 volumes, published separately. The first volume, 2011, which pretended to examine the circumstances surrounding the commando raid on the flotilla, although replete with scholarly footnotes and erudite references, proved on close inspection to be a whitewash. 144. The second volume, 2013, was mandated to assess whether Israel's mechanism for prosecuting violators of the laws of war met international standards. Unsurprisingly, the Turkel Commission found that the Israeli mechanism generally passed muster, but it also recommended several improvements. The UN report heaped praise on the Turkel Commission's recommendations, as they lent momentum to the noteworthy/significant/welcome reforms that Israel subsequently instituted. The UN report also delineated the remaining procedural, structural, and substantive flaws, already adumbrated by the Turkel Commission, and kept repeating, mantra style, that if Israel remedied them, its judicial system would come close to ensuring full legal accountability. A typical passage melding the bleak past with the roseate future went like this. The UN report is concerned that impunity prevails across the board for violations of international humanitarian and human rights law allegedly committed by Israeli forces, whether it be in the context of active hostilities in Gaza or killings, torture, and ill treatment in the West Bank. Israel must break with its recent lamentable track record in holding wrongdoers accountable. Those responsible for suspected violations of international law at all levels of the political and military establishments must be brought to justice. An important factor in enabling such a process will be the implementation of the Turkel Commission's recommendations. 145. The UN report's analysis zeroed in on Israel's legal mechanism as the critical locus in need of repair. Just a mite more tweaking, it anticipated, and everything would be hunky-dory. But the rational basis of its Pollyanna-ish optimism perplexes. Consider this chronology. The report highlighted that Israel had already implemented several of the Turkel Commission's proposed reforms. Before Protective Edge, and it praised these as noteworthy/significant/welcome initiatives. But it also noted that after Protective Edge, and notwithstanding these touted reforms, B'Tselem, Israeli Information Center for Human Rights in the Occupied Territories, and Yashdin, the premier guardians of Palestinian human rights in Israel, refused to cooperate with official Israeli inquiries into the operation. The existing investigation mechanism, they jointly declared, precluded serious investigations and is marred by severe structural flaws that render it incapable of conducting professional investigations. 146. It would appear that these Israel-based human rights organizations were rather less sanguine than the report about the alleged Israeli reforms. Furthermore, if these indeed constituted noteworthy/significant/welcome improvements, how did it come to pass that the material results of Israeli investigations into Protective Edge read like a carbon copy of Operation Cast Lead? As of 2015, the report noted, Israel had issued 3 indictments. 2 soldiers were accused of looting NIS 2,420, over $600, from a Palestinian home in Shuja'iyah, Gaza City. A 3rd soldier was accused of assisting them. Unless the report was of the opinion that an indictment for stealing cash instead of for stealing a credit card registered a civilizational leap, a wide chasm separated the report's brimming enthusiasms from these measurable outcomes. A year after publication of the UN report, B'Tselem issued a report of its own. The Occupation's Fig Leaf, Israel's military law enforcement system as a whitewash mechanism. 147 It announced that henceforth it would cease cooperating with Israel's military law enforcement system. Inter alia, it commented on the Turkle Commission, which so impressed the UN report. The Commission recommended a number of improvements to the military law enforcement system. The implementation of these recommendations, which has already begun, may improve appearances of the current system, but it will not remedy the substantive flaws. The B'Tselem report concluded. The semblance of a functioning justice system allows Israeli officials to deny claims made both in Israel and abroad that Israel does not enforce the law on soldiers who harm Palestinians. These appearances also help grant legitimacy to the continuation of the occupation. It makes it easier to reject criticism about the injustices of the occupation, thanks to the military's outward pretense that even it considers some acts unacceptable, and backs up the claim by saying that it is already investigating these actions. B'Tselem's cooperation with the military investigation and enforcement system has not achieved justice, instead lending legitimacy to the occupation regime and aiding to whitewash it. Here is no longer any point in pursuing justice and defending human rights by working with a system whose real function is measured by its ability to continue to successfully cover up unlawful acts and protect perpetrators. The purpose of Israeli pseudo-investigations undertaken after Protective Edge, B'Tselem further observed in a complementary publication. Whitewash Protocol, the so-called investigation of Operation Protective Edge, was to prevent the International Criminal Court, ICC, in The Hague from addressing the issue itself. 148 If only the UN report had summoned up such courage, candor, and principle, instead, it lent its good offices to the whitewash as it waxed the occupation's fig leaf. The UN report's assessment of Israel's accountability mechanism included a case study of 4 Palestinian children killed by Israeli missiles. 149 The children were playing hide-and-seek around a small, dilapidated fisherman's hut, which was in plain sight of nearby hotels housing international journalists, none of whom described seeing militants in the area at the time of the attack. British Guardian. 150 The report noted that the boys were aged between 9 and 11 years, and were therefore small in stature in comparison to the size of an average adult, while Amnesty noted that video footage quickly emerged in which individuals targeted were clearly visible as children. 151 But the official Israeli investigation concluded that the children had been mistaken for militants and that the attack process accorded with Israeli domestic law and international law requirements. If the report's legal assessment differed from Israel's, it was only on the narrowest of grounds. It found strong indications that the IDF failed in its obligations to take all feasible measures to avoid or at least minimize incidental harm to civilians. It is unclear why the report ruled out the possibility that the Israeli missile strikes intentionally targeted the children. It's not as if the IDF had never before targeted Palestinian children or, for that matter, tortured them. 152 And used them as human shields. 153 Or that Israeli settlers, many of whom at some point passed through the IDF, hadn't committed the most heinous atrocities against Palestinian children, such as burning them to death. 154 The report just barely, and only indirectly, paused to reflect on the plausibility of the claim that the IDF confused 4 children small in stature in comparison to the size of an average adult with Hamas militants. Thus, in keeping with its all feasible precautions line of analysis, the report criticized the IDF as it could have more exhaustively verified whether those being targeted were taking a direct part in the hostilities. What hostilities? The report itself stated, there were no IDF soldiers in the area, as the ground operations had not commenced, nor were there any other persons in imminent danger. Wasn't the report's tacit premise, that the IDF believed the children were taking a direct part in the hostilities? A leap of bad faith, unargued, unsubstantiated, and in light of a gory Israeli track record of killing and torturing Palestinian children wholly unwarranted? The report continued, THIRD compound was located in the center of a city of almost 550,000 residents, between a public beach and an area regularly used by fishermen. It could therefore not be ruled out that civilians, including children, might be present. These factual elements suggest that by assuming that the individuals were members of armed groups merely on the basis of their presence in a particular location, the IDF reversed the presumption of civilian status. This passage puzzles on several counts. First, the report took for granted that the target of the Israeli missile strike was a Hamas compound, even though journalist eyewitnesses attested that it was a beaten shack. Second, it itself acknowledged that the targeted area was a densely populated civilian locale. Third, it was most improbable that children small of stature would be confused with Hamas militants. Why then did the report infer that the IDF had been assuming that the individuals were members of armed groups? On the basis of the circumstantial evidence, which the report itself assembled, it would seem much more probable that the IDF deliberately targeted innocent children. Indeed, except for pro forma Israeli denials, no basis existed for inferring otherwise. By starting from the assumption that the children were militants, not civilians, instead of the reverse, the report concluded, Israel appears to have validated an incorrect application of international humanitarian law. The irony, entirely lost on this wretched document, was that by starting from the highly dubious premise that the IDF had been assuming the dilapidated shack was a Hamas compound, and the diminutive children were an armed group, the report itself validated an incorrect application of international humanitarian law. The applicable legal principle was not all feasible precautions but, plainly, the deliberate targeting of civilians. 155. The UN report's analysis of Israeli legal accountability was embedded in, and went awry because of, a chain of false, if anodyne, and convenient premises, to wit, Israel has periodically launched military operations in Gaza with legitimate, conventional military objectives and targets. In the course of these operations, the IDF has, alas, committed excesses which army hasn't, sometimes spilling over into war crimes. If Israel has been remiss in prosecuting these breaches of the laws of war, it's on account of a still flawed legal administrative mechanism. But fortunately it requires just a little tinkering if Israel would only implement a couple more Turkle Commission recommendations to eliminate the glitches and enable the wheels of justice to turn smoothly. The picture looks radically different, however, if Protective Edge is viewed through the optic of the Goldstone Report, issued by the UN Human Rights Council after Cast Lead. 156. The Goldstone Report found that the death and destruction Israel visited on Gaza's civilian population were not incidental or the result of a failure to take all feasible precautions but, on the contrary, calculated and deliberate, designed to punish, humiliate, and terrorize a civilian population. 157. The military doctrine driving Protective Edge was carried over from Cast Lead. It was a repeat performance, but writ larger. The factual evidence collected in the UN report left little space for doubt that Israel was deliberately targeting Gaza's civilian population and infrastructure during Protective Edge. If the report's legal analysis concluded otherwise, it was due not to a deficit of material evidence but to a deficit of moral integrity. The report deployed the idiom of law, not to shed light on the criminal nature of Israel's undertaking but to sanitize it. True, the report at multiple junctures raises concerns that Israel may have committed war crimes. But it willfully, repeatedly, and unforgivably ignored dispositive evidence that these Israeli crimes, far from being collateral to or springing from tactical excesses in the pursuit of a bona fide military objective, were integral to and inherent in a criminal strategy targeting Gaza's civilian population. Whether it traced back to careerism, cowardice, or cynicism, the bottom line was that the report transparently and shamelessly fled from the damning conclusions that flowed, inexorably, from its own factual findings. Did it not border on the absurd? Indeed, was it not squarely in absurdist terrain, when the report indicted Israel for not taking all feasible precautions to avoid incidental harm to civilians after Israeli missiles targeted and killed 4 children playing hide-and-seek in an open civilian area, absent any military activity, in broad daylight, in the presence of numerous credible eyewitnesses who contradicted Israel's pro forma denials on each and every point? In 2 places, the report pondered whether Israel's massive and destructive force was approved at least tacitly by decision-makers at the highest levels of the government, and gingerly touched on the role of senior officials who set military policy. Individual soldiers may have been following agreed military policy. It also posed the tantalizing question, why did the political and military leadership not revise their policies or change their course of action, despite considerable information regarding massive death and destruction in Gaza? It further noted that the relevant Israeli bodies had not initiated judicial proceedings against the military and civilian leadership. But still, the report chased after the will-o'-the-wisp that if the Turkle Commission recommendations were fully implemented, Israel's judicial system would hold to account individuals who may have played a role in wrongdoing, regardless of their position in the hierarchy. 158 In reality, if senior Israeli officials willfully persisted in a course of action causing murder and mayhem in Gaza, and if none of them was subsequently indicted, let alone convicted, it was no mystery at all as to why. The operation unfolded according to plan, and the plan enjoyed near universal support. If the report's authors didn't see this, that's because they didn't want to see it and didn't want anyone who read their findings and conclusions to see it. The report was a monument to sophistry, obfuscation, and deflection. It conjured up the absurd panacea of comprehensive and effective accountability mechanisms, 159, when in fact nearly the whole of Jewish Israeli society, from top to bottom and across the board, was united in the dual conviction on full display in the breaking the silence testimonies that Arab life was worthless and Jewish life worth its weight in gold. That, too, the report pretended not to see, and didn't want others to see. 160 For were this sordid reality to be acknowledged, its fateful implication would have to be confronted, that the obstacle to achieving justice was not localized but systemic. Israel will not reform itself because it cannot reform itself. It is contaminated at every level, not least the judiciary, by a virulent brew of racism and arrogance freely circulating in a body politic whose immune system has collapsed. By fostering the illusion that if Israel incorporated a handful of internal administrative reforms it would heal itself, the report conveyed and validated the utterly counterfeit image that Israel was essentially a healthy society, but a state that every couple of years launches with overwhelming popular support and without a hint of remorse yet another high-tech blitzkrieg against a defenseless, trapped civilian population is profoundly sick. If another protective edge is to be avoided and the people of Gaza are to be spared another massacre, it requires pressure to be exerted from without, not meaningless, irrelevant tinkering from within. The betrayal of Gaza by human rights organizations, chronicled in these pages, constitutes a harsh truth. Still, it must be brought to light. The beginning of wisdom, Confucius said, is to call things by their proper name. Conclusion. Figure 5. From left to right, starting at top left, Philip Luther, Amnesty International, Kenneth Roth, Human Rights Watch, Luis Moreno Ocampo, International Criminal Court, Mary McGowan Davis, UN Independent Commission of Inquiry, Jacques de Mayo, International Committee of the Red Cross, Richard Horton, The Lancet. Photo credits, Karen Hatch Photography, Harold Dettenborn, Estonian Foreign Ministry, Jean-Marc Fair, ICRC Audiovisual Archives, Blue Raspberry. A 2012 UN report posed the poignant question, will Gaza be a livable place in 2020? Its response, based on current trends, was just barely, while it would require Herculean efforts to reverse these trends. 1 The prognosis appeared yet bleaker a few years later. 3 Israeli military operations in the past 6 years, in addition to 8 years of economic blockade. A 2015 United Nations Conference on Trade and Development, UNCTAD, report found, have ravaged the already debilitated infrastructure of Gaza, shattered its productive base, left no time for meaningful reconstruction or economic recovery, and impoverished the Palestinian population in Gaza. At the time of writing, some 50% of Gaza's population is unemployed, while 70% is food insecure and dependent on humanitarian aid. 70% of the nearly 20,000 homes destroyed during Protective Edge have still not been rebuilt. 70% of Gazans have piped water supplies for only 6 to 8 hours every 2 to 4 days, while nearly all Gazans suffer from power outages lasting 16 to 18 hours each day. For the first time in a half-century, a team of health researchers found, mortality rates have increased among Palestine refugee newborns in Gaza. In answer to the question posed by the 2012 UN report, the 2015 UNCTAD report forecast that on the present trajectory, Gaza will be unlivable in 2020.2. It's possible that this projection, which gave Gaza a 5-year window of opportunity, was too sanguine. Another war with Gaza was inevitable, senior Israeli officials ominously observed in 2016. We cannot conduct a constant war of attrition. Therefore, the next conflict has to be the last conflict. 3. The proximate cause of Gaza's desperate plight is the siege. The 2015 UNCTAD report observed that the complete and immediate lifting of Israel's blockade is more urgent than ever if Gaza is to have a chance to avoid further damage and develop into a livable place. In a follow-up report a year later, UNCTAD again sounded the alarm. The population of Gaza is locked in, denied access to the West Bank and the rest of the world. Even people in need of medical treatment are not allowed to travel to obtain essential health care. Full recovery of the Gaza Strip is challenging without a lifting of the blockade, which collectively negatively affects the entire 1.8 million population of Gaza and deprives them of their economic, civil, social, and cultural rights, as well as the right to development. For the siege, which constitutes a form of collective punishment, is a flagrant violation of international law. The UN Human Rights Council report on Operation Protective Edge, although a whitewash and a sham, nonetheless called on Israel to lift the blockade immediately and unconditionally. 5. Israel's severe restrictions on exports from the Gaza Strip, Sarah Roy of Harvard University concluded, have little or anything to do with security. Their purpose clearly is to maintain the separation of Gaza and the West Bank. 6. Its severe travel restrictions, according to GISHA, the Israeli Legal Center for Freedom of Movement, result more from Israel's minimalist approach to its obligations toward the 1.8 million Palestinians living in the Gaza Strip than from its obligation to protect the security of Israeli citizens. The benefits to Israeli security are hard to identify. 7. Even Israel's prestigious newspaper Haaretz scoffed at the notion that the blockade provided security, and called for it to be lifted. There is no justification for the closure of Gaza. It hasn't prevented missiles from being fired at Israel. It hasn't caused the hoped-for public uprising against the Hamas government. And it constitutes an incubator for the development of despair and cycles of violence that have made the lives of residents of southern Israel intolerable. The Israeli government must immediately end its blockade of Gaza. This Palestinian ghetto must be opened. 8. In all likelihood, the lethal trends prefiguring Gaza's exhaustion as a viable habitat won't be checked. The political muscle needed to reverse Israeli policy vis-a-vis Gaza is sorely lacking. In the newly emerging constellation of regional and global political alignments, Israel's star is waxing, as it has made significant diplomatic inroads among key state actors. 9 Meanwhile, Palestine's star is on the wane. Whereas it benefited from a unique salience on the world stage this past half-century, the cause of Palestine has now been eclipsed by the numberless humanitarian crises racking the Middle East. Even if and when the dust settles, it's improbable that Palestine will regain its former moral resonance. Inexorably, it will be reduced to the minuscule geopolitical weight of its demography and territory, and come more closely to resemble the self-determination struggles in East Timor and Western Sahara. If it was an uphill battle before, the path henceforth will be immeasurably steeper. A cascade of recent developments impinging on Gaza flesh out this forbidding picture. At worst, regional players, such as Egypt, turn the screws on Gaza tighter than even Israel would counsel. 10 At best, regional players, such as Saudi Arabia, try to score points with Arab public opinion and purchase local patronage by earmarking aid packages in the event, mostly unfulfilled for Gaza. 11 None of the regional powers, however, is about to expend political capital on Gaza's behalf. On the contrary, both Egypt and Saudi Arabia are forging a long-term strategic alliance with Israel. 12 After the Mavi Marmara incident, Turkey conditioned a resumption of normal relations with Israel on an end to the blockade. 13 But in 2016, President Recep Tayyip Erdogan capitulated. He re-established diplomatic ties after derisory Israeli concessions enabling him to save face. 14 In the meantime, the Middle East Quartet, the US, EU, UN, and Russia issued in 2016 a long-awaited statement on the peace process. It pinned primary culpability for the deterioration in Israeli-Gazan relations on the illicit arms buildup and militant activity by Hamas, and it determined that preventing the use of territory for attacks against Israel is a key commitment that is essential for long-term peace and security. Its only direct mention of the horror that unfolded during Protective Edge read, in the course of the 2014 conflict, Israel discovered 14 tunnels penetrating its territory. The report did acknowledge in passing that the dire humanitarian situation in Gaza was exacerbated by the closures of the crossings, and that Israeli restrictions on external trade and access to fishing waters contribute to food insecurity and humanitarian aid dependency. But the quartet called on Israel not to end but only to accelerate the lifting of movement and access restrictions to and from Gaza, and then interpolated the escape clause that due consideration should be given to Israel's need to protect its citizens from terrorist attacks. 15 Thus, so long as Israel purports that sealing off Gaza from the outside world is necessary to protect itself from Hamas terrorism, or, in other words, until and unless Gaza surrenders its fate to Israel, the siege will continue with the quartet's blessing. Of the complementary international reconstruction plans for Gaza, Roy observes, they read more like security plans, carefully laying out Israeli concerns and the ways in which the United Nations will accommodate them. Israel must approve all projects and their locations, and will be able to veto any aspect of the process on security grounds. Not only will the blockade of Gaza be maintained, but responsibility for maintaining it will in effect be transferred to the UN, which is tasked with monitoring the entire process of which Israel retains full control. 16 True, after a visit to Gaza in 2016, UN Secretary-General Ban Ki-moon told a news conference, the closure of Gaza suffocates its people, stifles its economy and impedes reconstruction efforts. It is a collective punishment for which there must be accountability. 17 Alas, he only reached this epiphany 6 months before the end of his 10-year term of office. In the instant case, late was not better than never, it was never. Gaza has not yet crossed the threshold of no return. To be sure, one would have to be blinder than King Lear to believe that diplomatic negotiations in and of themselves might yet yield fruit. When the current phase of the peace process was inaugurated in 1993, 250,000 illegal Jewish settlers resided in the occupied Palestinian territory. By 2016, 600,000 settlers resided in the West Bank, including East Jerusalem. The bitter fruit it yielded in Gaza requires no further comment. If the essence of a phenomenon is to be grasped not in its packaging but in its content, then Palestine has borne witness not to a peace process but to an annexation-cum-despoliation process. The quartet report called for the resumption of meaningful negotiations. But it isn't possible to resume what never began. Still, it is no more likely that Hamas's strategy of armed resistance can achieve substantive results. However legally and morally defensible, firing bottle rockets at one of the world's most formidable military powers will not bring it to its knees. It merely provides Israel with a convenient alibi when it periodically decides in pursuit of objectives wholly divorced from these rockets to annihilate Gaza. A strategy of mass nonviolent resistance, by contrast, might yet turn the tide. Gaza's richest resources are its people, the truth, and public opinion. Time and again, and come what may, the people of Gaza have evinced a granite will, born of a sheer indomitable dignity. UNRWA spokesperson Chris Gunness, not to be held in bondage. 18 Protective edge battered that will but, it appears, did not yet shatter it. Truth is on the side of Gaza. If this book rises to a crescendo of anger and indignation, it's because the endless lies about Gaza by those who know better cause one's innards to writhe. Gandhi called his doctrine of nonviolence satyagraha, which he translated as hold on to the truth. If the people of Gaza, in their multitudes, hold on to the truth, it's possible, which is not to say probable, let alone certain, just possible and not without immense personal sacrifice, up to and including death, that Israel can be forced to lift the suffocating blockade. What iron dome or what tunnel detection system can stop them? An Israeli observer rhetorically asked, if one day a few tens of thousands, or maybe a few hundreds of thousands, decide to climb the fence, or hold a hunger strike next to it. 19 The cause of Palestine still inspires and can draw from huge reserves of international public support, including in recent years wide swaths of Jewish opinion estranged from Israel's lurch rightward and leap into the moral abyss. 20 At the core of this mass of sympathetic opinion stands an international solidarity movement ready, willing, and able, when the moment of reckoning is upon it, to give its all for Gaza. If the people of Gaza, on the one hand, and global public opinion, on the other, are mobilized, galvanized, and organized, and if a cause guided by truth, fortified by law, animated by righteousness, and bending toward justice can unleash, as history is testament, an irresistible moral power able to defeat, disarm, and diffuse brute force, then a small miracle might yet come to pass. The people of Gaza will be able, at least, at last, to breathe again, and ultimately, if we all persevere, to end the occupation. In A Century of Dishonor, written at the end of the 19th century, Helen Hunt Jackson chronicled the destruction of the Native American population by conscious, willful government policy. The book was largely ignored, then forgotten, and finally rediscovered by later generations ready to hear and bear the truth. Speaking to the fate of the Cherokee Nation, which was expelled from one tribal homeland after another and finally stripped of its tribal holdings by the U.S. government, Jackson wrote, "There is no record so black as the record of its perfidy to this nation." 21 The present volume was modeled after her searing requiem. The author holds out faint hope that it will find an audience among his contemporaries. Still, the truth should be preserved, it is the least that's owed the victims. Perhaps one day in the remote future, when the tenor of the times is more receptive, someone will stumble across this book collecting dust on a library shelf, blow off the cobwebs, and be stung by outrage at the lot of a people, if not forsaken by God then betrayed by the cupidity and corruption, careerism and cynicism, cravenness and cowardice of mortal man. There will come a time, Jackson anticipated, when, to the student of American history, it will seem well nigh incredible what was done to the Cherokee. Is it not certain that one day the black record of Gaza's martyrdom will in retrospect also seem well nigh incredible? Appendix. Is the occupation legal? Abstract. A broad consensus exists among representative and authoritative bodies that under international law, the Israeli blockade of the Gaza Strip is illegal and, even after its 2005 redeployment, Israel remains the occupying power in Gaza. But what is the legal status of the Israeli occupation itself? The essence of an occupation under international law is that it is a temporary situation. An occupation that does not, and cannot, and is de facto an irreversible annexation. Inasmuch as the acquisition of territory by war is illegal under international law, an occupation that morphs into an irreversible annexation must also be illegal. In light of the International Court of Justice's jurisprudence in the Namibia case, on the one hand, and Israel's persistent refusal to negotiate an end to the occupation on the basis of international law, on the other, it is submitted that the Israeli occupation of the West Bank, including East Jerusalem, and the Gaza Strip, has become illegal under international law. As such, Israel has forfeited its rights as an occupying power. The one and only right still accruing to it is to execute a full withdrawal from the Palestinian territories that it illegally occupies. 1.0. The International Law of Occupation. 1.1. Does the legal status of an occupation depend on how it originated? 1.1.1. The broad consensus is that international law does not distinguish between a military occupation that results from a war of self-defense and a military occupation that results from a war of aggression. The same rights and obligations, codified in the Hague Regulations, 1907, and the Fourth Geneva Convention, 1949, accrue to the occupying power in either case. One, it thus resembles the laws of war, which apply equally to both parties in a conflict regardless of which side initiated it and which acted in self-defense. 1.1.2. A dissenting view, based on more recent developments in international law, holds that military occupation is intrinsically illegal, as it results from illegal use of force and violates the customary law of self-determination. The sole exception would be an occupation that both ensues from lawful use of force and is of limited duration. 2. 1.1.2.1. Even if one subscribes to the novel contention that a military occupation is inherently illegal, and even if the Israeli occupation did not qualify as an exception, it still could not circumvent the fact that UN Security Council Resolution 242, which endures as the recognized basis for resolving the Israel-Palestine conflict, made Israel's withdrawal conditional on a negotiated agreement. However it originated, Israel's occupation cannot then be illegal by virtue of it being an occupation. 1.1.2.2. The preambular paragraph of a December 1975 General Assembly resolution, Implementation of the Declaration on the Granting of Independence to Colonial Countries and Peoples, 3481, recited that any military occupation, however temporary, constituted an act of aggression, and an operative paragraph accordingly condemned Israel's occupation of Arab territories in violation of the Charter of the United Nations, the principles of international law and repeated United Nations resolutions 3. But this isolated resolution does not appear to have had political consequence or diplomatic resonance. 1.1.3. In the early years of the occupation, it was alleged by Israel's supporters that insofar as Israel came to administer the Arab territories while fighting a defensive war, it was a lawful entrant that has a right of occupation, pending conclusion of a peace treaty. For if the Israeli occupation was legal, it was allegedly because it sprang from a war of self-defense. 1.1.3.1. This contention was anchored in the two-pronged claim that Israel, believed it, faced an imminent Egyptian attack when it struck in 1967, and that Israel's resort to force was subsequently validated by the United Nations. A careful reading of the documentary record shows, however, that an Egyptian attack was not impending. Israeli leaders did not fear such an attack, and the international community did not ex post facto embrace Israel's narrative of the chain of events climaxing in its first strike. 5. 1.1.4. Even though the international community did not embrace Israel's narrative of how it came to occupy Arab lands, it did not call on Israel to unilaterally withdraw. After protracted debate, first in the General Assembly and then in the Security Council 6, the United Nations resolved, in 242, to make an Israeli withdrawal from occupied Arab territory, in accordance with the customary rule of the inadmissibility of the acquisition of territory by war, conditional upon the termination of all claims or states of belligerency by neighboring Arab countries, in accordance with the principle of international law barring threat or use of force against the territorial integrity or political independence of any state. 1.1.5. The essential picture, then, is that the legality of Israel's occupation does not hinge on how it originated. Whether the occupation resulted from a war of self-defense or a war of aggression is beside the point. Even if Israel's claim of self-defense could be shown to be false, still Israel was not legally bound to withdraw so long as neighboring Arab countries did not recognize its reciprocal rights as a state. The Israeli occupation had no time limit and could, from the legal point of view, continue indefinitely, former Israeli Chief Justice Meir Shamgar inferred, pending an alternative political or military solution. 7. 1.2. The legal status of a recalcitrant occupier. 1.2.1. But could the Israeli occupation from the legal point of view continue indefinitely if Israel balked at withdrawal even after Arab states expressed a readiness to recognize it? Shamgar entered the critical caveat, pending an alternative political solution. What if Israel were offered such a solution, but rejected it? 1.2.2. This question first arose in the context of Israel's occupation, following the 1967 war, of the Egyptian Sinai. In the course of unmandated mediation, the Jarring Mission, Egypt had agreed to a full peace treaty with Israel, but Israel still refused to withdraw from the Sinai. Once these negotiations broke down, and all avenues toward a diplomatic settlement were thwarted by Israeli intransigence, Egypt repeatedly warned that it would go to war in order to recover the occupied Sinai. It made good on this threat in 1973.8. 1.2.2.1. Just before Egypt launched its offensive, the UN Security Council convened to deliberate on the diplomatic impasse. Israel purported that per Resolution 242, it was not obliged to withdraw until and unless a mutually agreed upon resolution of the conflict was reached. The Kingdom of Jordan cogently rejoined, however, that disputing axiomatic legal principles did not constitute negotiations but, instead, was tantamount to evading a settlement. While agreement has a necessary and proper place in the peacemaking efforts, it should not be allowed to be employed as a subversive tactic and pretext. One cannot reopen every established and fundamental principle of the UN Charter and its logical consequences. At every juncture at which a party to a dispute deems it serviceable to its illegitimate interest to veto the application of the principles. We wish that complete withdrawal should occur through agreement. But if the party in occupation and in objective opposition to a just settlement insists on placing its non-agreement as a barrier to both withdrawal and peace, what are we to do? 9. 1.2.2.2. A draft resolution tabled at this council session strongly deplored Israel's continuing occupation of the territories occupied as a result of the 1967 war. 10. In his gloss on the resolution, the Indian drafter stated, "We totally reject any claim that either Resolution 242, 1967, or the ceasefire agreement in any way gives tolerance, much less authority, direct or indirect, tacit or implicit or explicit, for Israeli forces to continue to occupy Arab territories." 11. The United States vetoed the resolution on the grounds that condemning the Israeli occupation bears no relationship to the provisions and principles of Resolution 242, 1967. 12. But the consensus opinion minus the American delegate was that once Israel refused to negotiate a peaceful settlement based on international law, it effectively forfeited its right to be an occupant. In keeping with this determination, after Egypt crossed the Suez Canal in October 1973 in order to eject the Israeli occupier and recover the Sinai, not a single government accused Egypt of aggression, as Abba Eban later wrote in his memoir. Not even the United States. 13. 1.2.3. The scholarly literature on the law of occupation makes scant mention of the legal status of a recalcitrant occupier. The most comprehensive study to date, Yutaka Ere Takahashi's The Law of Occupation, Continuity and Change of International Humanitarian Law, and its Interaction with International Human Rights Law. 14 doesn't contemplate such a scenario. Yoram Dinstein's The International Law of Belligerent Occupation disposes of the myth that an occupation becomes in time inherently illegal under international law in one Kurd, Unenlightening paragraph point 15. 1.2.3.1. An article by Orna Ben Naftali, Eyal Gross, and Karen Michaeli, Illegal Occupation, Framing the Occupied Palestinian Territory, 16 is often cited by writers who assert that Israel's occupation is illegal. It argues, albeit in occasionally opaque language, that the infrastructure Israel has entrenched in the West Bank, settlements, bypass roads, the wall, etc., constitutes a de facto annexation, in violation of the basic principle of temporariness that defines an occupation, and that Israel has also committed gross violations of humanitarian and human rights norms in the annexation process. The cumulative effect of these illegal Israeli actions, the authors conclude, has been to render the occupation illegal. The force of this thesis is that Israel has been pursuing policies that will eventually and inexorably make the occupation irreversible, in breach of its obligations as an occupier, on the one hand, and the Palestinian right to self-determination, on the other. But inasmuch as Israeli settlements, etc., have not yet made the occupation irreversible, it appears legally more nuanced, and in keeping with precedent, to discreetly condemn the illegal Israeli practices without however declaring the occupation as such illegal. 1.2.3.1.1. The UN Security Council has designated Israel's settlement policy and annexation of East Jerusalem illegal 17, and the General Assembly has referred to Israel's de facto annexation of large areas of territory 18. 1.2.3.1.2. In its 2004 landmark advisory opinion, Legal Consequences of the Construction of a Wall in the Occupied Palestinian Territory, the International Court of Justice, ICJ, more tentatively stated, the construction of the wall and its associated regime create a fait accompli on the ground that could well become permanent, in which case, and notwithstanding the formal characterization of the wall by Israel, it would be tantamount to de facto annexation. 19. In a separate opinion, however, Judge Korama concluded without qualification that the construction of the wall has involved the annexation of parts of the occupied territory by Israel. 20. 1.2.3.1.3. Eminent international law specialist James Crawford has observed that the Israeli settlements constitute a de facto annexation of West Bank territory that has prevented the Palestinian people from exercising their right to self-determination. 21. 1.2.3.1.4. However, neither the Security Council nor the General Assembly, neither Judge Korama nor Crawford, determined that Israel's annexation of Palestinian territory perforce rendered the occupation itself illegal. The prudent determination would appear to be that even if an occupier's recalcitrance has over time resulted in a de facto, or, in the case of East Jerusalem, de jure, annexation, it doesn't yet illegalize the occupation as such. 1.2.3.1.5. For the record, Israel's official position is that the Jewish settlements, and the wall running along the periphery of the major settlement blocks, are inherently temporary. Israel High Court of Justice, 22, and do not annex territories to the State of Israel. 23. In the course of the wall's construction, however, senior Israeli government officials, including former Justice Minister Tzipi Livni, former Prime Minister Ariel Sharon, and former Defense Minister Ehud Barak, publicly conceded that the wall marked off Israel's future border. 24. 1.2.3.2. Israeli legal scholar Eyal Ben-Venisti tackles the legal challenge posed by a recalcitrant occupier from a different angle in The International Law of Occupation. He begins, like Shamgar, by asserting that international law neither limits the duration of the occupation and/or requires the occupant to restore the territories to the sovereign before a peace treaty is signed. However, Ben-Venisti then enters this caveat: an occupation regime that refuses to earnestly contribute to efforts to reach a peaceful solution should be considered illegal. Indeed, such a refusal should be considered outright annexation. The occupant has a duty under international law to conduct negotiations in good faith for a peaceful solution. It would seem that an occupant who proposes unreasonable conditions, or otherwise obstructs negotiations for peace for the purpose of retaining control over the occupied territory, could be considered a violator of international law. He goes on to observe that an occupant that in bad faith stalls efforts for a peaceful ending to its rule would be considered an aggressor and its rule be tainted with illegality. 25. 1.2.4. The determination that if an occupier negotiates in bad faith, then it has tainted the occupation with illegality was in fact already arrived at in the Namibia case. After protracted, fruitless negotiations, the UN General Assembly followed by the Security Council passed resolutions declaring South Africa's occupation of Namibia illegal, and subsequently the ICJ upheld the validity of these UN decisions. The Namibia case bears strong resemblances to the Israeli occupation of Palestinian territory. Its unfolding and denouement provide a roadmap for the international community as it confronts another recalcitrant occupier. 2.0. The Namibia case. 2.1. Historical context. 2.1.1. Although largely forgotten today, in the mid-20th century the Namibia Mandate of South Africa prompted more resolutions, promoted more committees and produced more judicial decisions, recalled leading authority John Dugard, than any other matter to come before the organs of the United Nations. It was, in Dugard's words, the international cause célèbre. 26 or, as one of the ICJ judges hearing the case put it, the most explosive international issue of the post-war world. 27 In later years, it was displaced on the international agenda by the larger question of South African apartheid, of which Namibia was henceforth a subsidiary issue, and by the Palestine question, which was the other gaping wound lingering from the mandate's era. 2.1.2. After seizing power in Russia, the Bolsheviks denounced World War I as imperialistic and trumpeted their support for the principle of self-determination of oppressed nations. Largely in reaction and as a result, U.S. President Woodrow Wilson himself championed the right of self-determination and imposed on the Allied powers the principle of non-annexation of the colonies of the defeated Central Powers. 28. 2.1.3. A mandates system was created at war's end and codified in Article 22 of the League of Nations Covenant. Each of the former colonies of the Central Powers, allegedly not yet able to stand by themselves under the strenuous conditions of the modern world, came under the tutelage of an advanced nation that was mandated to prepare it for the exercise of self-determination. The tutelary role of the mandatory power, acting on behalf of the League to promote the ex-colonies' well-being and development, was denoted a sacred trust of civilization. 2.1.4. The mandate over the former German colony of Namibia, Southwest Africa, was conferred on His Britannic Majesty to be exercised on his behalf by the Government of the Union of South Africa. Under the mandate's terms and subject to oversight by the League, and ultimately the Permanent Court of International Justice, South Africa was obliged to promote to the utmost the material and moral well-being and the social progress of the inhabitants. 2.1.5. After the League's dissolution in 1946, it was clearly contemplated 29 that the Namibia Mandate would be converted into a UN trusteeship, en route to statehood. 30 South Africa envisaged a different future, however, as it was intent on annexing Namibia, or the most desirable parts thereof. 31. 2.1.6. Thence ensued a protracted political and legal tug-of-war. The United Nations, led by a contingent of African states, demanded that South Africa recognize the General Assembly's supervisory powers and Namibia's right to independence, while in the face of Pretoria's persistent stonewalling, it simultaneously kept referring the Namibia question to the ICJ in order to clarify and certify South Africa's legal obligations. 2.1.7. A sequence of contentious and divisive proceedings unfolded at The Hague. 2.1.7.1. In a 1950 advisory opinion. International status of Southwest Africa. The ICJ concluded that even after dissolution of the League of Nations, South Africa was still duty-bound to promote the material and moral well-being and the social progress of the inhabitants, that the League's supervisory powers over South Africa's mandate had been transferred to the General Assembly, and controversially that although it was expected that the mandatory states would follow the normal course indicated by the Charter, namely, conclude trusteeship agreements, still South Africa was not legally obligated to convert its mandate into a UN trusteeship, but it also couldn't unilaterally modify Southwest Africa's international status. 2.1.7.1.1 In a cluster of dissents on this last point, Judge Alvarez asserted that the Union of South Africa has the legal obligation to negotiate and conclude an agreement with the United Nations to place Southwest Africa under trusteeship. Judge de Visser, supported by Vice President Guerrero, Judge Zorisic, and Judge Badawi Pasha, opined that South Africa incurred a legal obligation to be ready to take part in negotiations and to conduct them in good faith with a view to concluding a trusteeship agreement, and Judge Krulov maintained that South Africa was under the legal obligation to negotiate with a view to concluding a trusteeship agreement. 32. 2.1.7.2 A 1955 advisory opinion. Southwest Africa voting procedure. Hinged on a technical point regarding the substance and procedure of General Assembly oversight of South Africa's Namibia mandate. The court upheld the Assembly's prerogatives. 33. 2.1.7.3 In a 1956 advisory opinion. Admissibility of hearings of petitioners by the Committee on Southwest Africa. The court upheld the General Assembly's right to make use of supplementary procedures, such as oral testimonies by Namibian petitioners before a UN subcommittee, to facilitate its supervisory function in the face of South African intransigence. 34. 2.1.8 The proceedings at The Hague reached a tempestuous denouement in a pair of complementary yet contradictory court decisions in 1962 and 1966. 2.1.8.1 Ethiopia and Liberia, both formerly belonging to the League of Nations, invoked a clause of the League mandate enabling then member states to contest via court adjudication a mandatory's conduct. They requested from the ICJ not an advisory opinion but an enforceable judgment. 35 On, inter alia, their contention that South Africa had breached its obligations to promote to the utmost the material and moral well-being and social progress of the inhabitants of Namibia, and instead practiced apartheid, i.e., it has distinguished as to race, color, national or tribal origin, in establishing the rights and duties of the inhabitants. 2.1.8.2 The, in, famous case divided into two theoretically discrete phases, jurisdiction and merits. In its 1962 judgment, the court answered affirmatively that it had jurisdiction to render a decision. 36 But then in the 1966 judgment, when it was due to decide on the merits of the case against South Africa. 37 The ICJ effectively reversed itself. 38 Declaring, in the most controversial judgment in its history, 39 that it in fact lacked jurisdiction, as the applicant states could not demonstrate any legal right or interest appertaining to them in the subject matter of their brief against South Africa. 40. 2.1.8.3 Whereas both phases of the case formally turned on technical, linguistic, and historical arcana, what Judge Forster in his dissent rightly ridiculed as an arid scrutiny and relentless analysis. 41 And whereas it was subsequently purported by judges in the case and by legal commentators alike that it was conflicting judicial philosophies, teleologists versus positivists, that rent the court, a disinterested observer cannot but conclude that each side was able to marshal compelling evidence. 42 That the case each side mounted at The Hague was tendentious, and that the schism on the court was, at its core, and however crude and reductionist it might sound, political. The Old World colonial powers straining to reign in the non-Western upstarts, albeit with the curious anomaly that whereas the Old World was predictably represented by a tenacious and learned, if frankly obnoxious, Brit on the court, Judge Fitzmaurice, his arch-nemesis, who was also every bit his athletic and intellectual match, happened to be an American. Judge Jessup. 43. In a rare departure from judicial etiquette, which sustains the illusion of law standing above the political fray, Judge de Castro, in a later separate opinion, baldly, but still accurately, depicted the ICJ proceedings on Namibia as in their essence the struggle between the colonialists and progressives. 44. 2.2. South Africa's failure to negotiate in good faith, UN deliberations. 2.2.1. Appalled by the ICJ's dismissal by deflection of the case against South Africa, and the attendant squandering of years of time and resources invested in legal proceedings. 45. The United Nations took a series of dramatic and drastic steps to right the court's wrong. A 1966 General Assembly Resolution, 2145, terminated South Africa's mandate over Namibia. A 1967 Resolution, 2325, declared that the continued presence of South African authorities in Southwest Africa is a flagrant violation of its territorial integrity, and a 1968 Resolution, 2372, condemned the action of South Africa to consolidate its illegal control over Namibia, and called upon all states to desist from those dealings with the government of South Africa which would have the effect of perpetuating South Africa's illegal occupation. 2.2.2. Emphasizing the inalienable right of the Namibian people to freedom and independence and the legitimacy of their struggle against foreign occupation, the General Assembly justified its resolve, in 2145, to terminate South Africa's illegal occupation under three heads. Breach of international obligations. South Africa's administration in Namibia violated the mandate, the Charter of the United Nations and the Universal Declaration of Human Rights. Imposition of apartheid. The policies of apartheid and racial discrimination practiced by the government of South Africa in Southwest Africa constituted a crime against humanity, and failure to negotiate in good faith. The efforts of the United Nations to induce the government of South Africa to fulfill its obligations in respect of Namibia have been of no avail. 2.2.3. For the purposes of the argument presented here, the focus in this text will be on the last of these rationales. 2.2.4. The failure of South Africa to negotiate in good faith had already been moot in the ICJ deliberations on Namibia prior to the General Assembly resolutions. 2.2.4.1. In a dissenting opinion, 1950, Judge Alvarez stated, "It would not be possible to admit that an agreement which is intended to fix an important international status cannot be established solely because of the opposition, the negligence, or the bad faith of one of the parties. If it is impossible to reach such an agreement, the United Nations must then take the appropriate measures." 46. In a cognate dissenting opinion, 1950, Judge de Vischer, albeit more restrainedly, stated, "The mandatory power, while remaining free to reject the particular terms of a proposed agreement, has the legal obligation to be ready to take part in negotiations and to conduct them in good faith with a view to concluding an agreement." 47. 2.2.4.2. In a separate opinion, 1962, Judge Bustamante pointed to the overwhelming proof not only of the fact that repeated and reiterated negotiations took place, but also that all the efforts made to find a conciliatory solution resulted in failure. For 15 consecutive years this fundamental opposition of points of view, this unyielding opposition of the mandatory in the face of the virtual unanimity of member states as to the limits and obligations flowing from the mandate, have maintained a situation of permanent deadlock. He proceeded to conclude that no negotiation is possible and that any further negotiation would be ineffective to settle the dispute, counseling instead resort to judicial decision at The Hague in order to re-establish the harmonious functioning of the system. 48. 2.2.4.3. In a separate opinion, 1962, Judge Jessup observed that although there certainly is no absolute litmus test which would enable a court to assert in all situations at just what moment settlement by negotiation becomes impossible, it seems clear on the face of the record that the condition is fulfilled in this case. States, he pithily concluded, are not eternally bound by the old adage, If at first you don't succeed, try again. 49. 2.2.5. The General Assembly debates that culminated in a cascade of resolutions terminating South Africa's mandate and condemning its illegal occupation of Namibia zeroed in on South Africa's obduracy during negotiations, while also ridiculing South Africa's appeal to guard against the shutting of doors to further dialogue which is so necessary for better understanding and cooperation. 50. 2.2.5.1. Whereas the member states contended that the objective of negotiations was to secure Namibia's eventual independence, South Africa insisted on negotiations without set preconditions or a predetermined outcome, technically leaving open all possibilities, but in reality excluding real independence. 51. 2.2.5.2. The Ethiopian delegate gestured to the fact that all avenues of peaceful negotiations have already been exhausted. 52. While the Norwegian delegate noted, after 20 years of futile discussions about the South African administration of Southwest Africa, the consensus has arisen that South Africa has lost its right to administer the territory and that its mandate is terminated. 53. 2.2.5.3. In the face of the unbelievable intransigence of the government of South Africa, the Uruguayan delegate recollected, we find a whole slew of General Assembly resolutions covering a period of 20 years and urging Pretoria to fulfill its duties and assume its responsibilities before the international community. WEC an accumulation of acts of insubordination, violation, of disregard of authority, abuse of rights, disobedience, mockery, and defiance committed by South Africa against the United Nations. We have waited over 20 years. Let us hope that moderation will not become the vice of weakness. We are supported by law, by rights, by morality, by the will of the whole world. The time has come to put an end to the struggle between law and arrogance. The organ of the international community must end the mandate on the grounds of repeated and malicious non-fulfillment of the obligations and duties inherent in it. 54. 2.2.5.4. After recalling that for over 15 years we have waited for the South African government to comply with its clear obligations, and that our repeated attempts by the General Assembly to persuade the South African government to adopt a policy of cooperation have been unsuccessful, the British delegate, Lord Caradon, who would later craft UN Security Council Resolution 242, declared that South Africa has in effect forfeited its title to administer the mandate. 55. 2.2.5.5. The Israeli delegate, joining the majority, observed that the Assembly had turned to the ICJ in 1966 for a binding decision only after a deadlock had been reached in negotiations with South Africa to secure implementation of the 1950 ICJ advisory opinion on Namibia, that after the ICJ shied away from deciding the case in 1966, the decision now falls clearly on the shoulders of the General Assembly, and that South Africa was in breach of its major obligations because it did not prepare Namibia for independence. In a passage worth quoting at length, the Israeli delegate concluded, nearly 50 years after the mandate was conferred on and accepted by the mandatory power, Southwest Africa seems no nearer independence than it ever was. It is an ironic reflection that nearly all the other African peoples live under their own national sovereignty, while, in the case of Southwest Africa, and only in that case, the sacred trust of civilization remains not only unfulfilled, but also not even within sight of fulfillment. It is a fact that all efforts to reach a mutually acceptable and reasonable settlement have been exhausted. Since the mandatory power is failing to fulfill its essential obligations under the mandate, it follows that the United Nations is free to take appropriate action. We believe that the General Assembly is now entitled to terminate the mandate. The General Assembly should take decisions on the future of the mandated territory on the assumption that the mandate may be lawfully and properly terminated by the General Assembly. If the time frame is enlarged to nearly 100 years after the mandate, and if the statement that Southwest Africa was the only mandate where independence had not been within sight of fulfillment is amended by interpolating that the statehood of the indigenous population under the Palestine Mandate also was, and continues to be, placed on hold 56. Then the pertinence and unique resonance of the Israeli ambassador's observations, both as to diagnosis, all efforts to reach a mutually acceptable and reasonable settlement have been exhausted, and as to proposed remedy, the General Assembly is now entitled to terminate the mandate, can hardly escape notice. 57. 2.2.5.5.1. A few months later, the Israeli delegate told the Assembly, "The problem of Southwest Africa, which has developed into an intolerable situation, has been before the United Nations since its very first meetings over 21 years ago. Every conceivable approach to reaching a solution, which would conform to the principles of the Charter and assure the people of that land of their fundamental rights, has been thwarted. The United Nations has shown patience and even leniency in the face of the stubborn stand persisted in by the government of South Africa in utter disregard of the clearly expressed position of the United Nations." 58. In an earlier address, Israeli Foreign Minister Abba Eban exhorted the Assembly to insist that a mandatory power forfeits its mandate when it flagrantly and constantly violates the central aims for which the trust was conferred. 59. 2.2.5.6. The U.S. delegate, also standing with the Assembly majority in the deliberations, declared that by virtue of the breach of its obligations, South Africa forfeits all right to continue to administer Namibia. 60. Despite the walls of censorship and propaganda, with which their own government has surrounded them, he prognosticated, the people of South Africa must soon realize that the system they are trying to entrench in Namibia will not work, that it will neither satisfy the wants and needs of the non-white population nor, by some conjuring trick, conveniently make them disappear. 61. 2.2.5.6.1. The United States condemned South Africa as well for its imposition in Southwest Africa of its universally condemned policy of apartheid, and for its clear defiance of the General Assembly's wise injunction that South Africa refrain and desist from any action, constitutional, administrative, political or otherwise, which will in any manner whatsoever alter or tend to alter the present international status of Southwest Africa. 62. 2.2.5.6.2. What's more, the United States opined that if some Namibians living under occupation resorted to force, it was at root a reaction to South Africa's repressive tactics that bred desperation, and in that desperation some have found no alternative to violence as an expression of the determination to be free. The United States does not condone violence. The United States does condemn the brutality of a government whose official policies have bred violence by closing avenues of peaceful dissent in Southwest Africa, thereby generating the very behavior it seeks to punish. 63. 2.2.5.6.3. The actions of the United States did not, however, rise to its lofty rhetoric. The United States of America is economically and militarily the strongest among us, a Caribbean delegate observed. If it wished it could, I have no doubt, reduce the government of South Africa single-handedly, and indeed, it could do this even if the rest of us were to raise our voices against it. But even as we have heard the representative of the United States regret, abhor, and condemn the behavior of South Africa in this very chamber, he went on to rue, the existence of a domestic lobby that is sufficiently influential, may cause even the most determined government to pause. 64. Plus ca change, plus say la même chose. 2.2.6. Although lagging behind, the Security Council eventually echoed the resolve of the General Assembly. 2.2.6.1. The Council was first seized of the Namibia question in early 1968, when a resolution, 245, took note of the Assembly's termination of the mandate and expressed grave concern over South Africa's illegal repression in Namibia, while another resolution, 246, later that year censured the government of South Africa for its flagrant defiance of the Security Council. 2.2.6.2. A 1969 resolution, 264, took note of the grave consequences of South Africa's continued occupation of Namibia, affirmed that the continued presence of South Africa in Namibia is illegal, and called upon the government of South Africa to immediately withdraw its administration from the territory. A follow-up resolution, 269, later in the year declared that the continued occupation of the territory of Namibia by the South African authorities constitutes an aggressive encroachment on the authority of the United Nations, recognized the legitimacy of the struggle of the people of Namibia against the illegal presence of the South African authorities in the territory, and called upon South Africa to withdraw its administration from the territory immediately. 2.2.6.3 Faced with Pretoria's refusal to either negotiate in good faith or withdraw, the Security Council, in a 1970 resolution, 276, declared that the United Nations decided that the mandate for Southwest Africa was terminated, that the continued presence of the South African authorities in Namibia is illegal, and that consequently all acts taken by the government of South Africa on behalf of or concerning Namibia after the termination of the mandate are illegal and invalid. It also called for the creation of a subcommittee to study ways and means of implementing the relevant UN resolutions in the light of the flagrant refusal of South Africa to withdraw from Namibia. A few months later, the subcommittee recommended that the United Nations seek another ICJ advisory opinion. 2.3 South Africa's failure to negotiate in good faith, back to The Hague. 2.3.1 Pursuant to the subcommittee's recommendation, the Security Council adopted, in 1970, a pair of complementary resolutions. The first of these, 283, reaffirmed its recognition of the decision of the General Assembly to terminate the mandate of South Africa, noted with great concern the continued flagrant refusal of the government of South Africa to comply with the decisions of the Security Council demanding immediate withdrawal, and called upon all states maintaining diplomatic or consular relations with South Africa to issue a formal declaration to the effect that they consider South Africa's presence in Namibia illegal. The succeeding resolution, 284, referred the Namibia question back to the ICJ. 2.3.1.1 Defending this course of action against skeptics still smarting from the court's 1966 snub, see Supra, 2.1.8.2, the Finnish delegate on the Security Council stressed that an advisory opinion of the International Court of Justice could underline the fact that South Africa has forfeited its mandate over Southwest Africa because South Africa has acted contrary to international law. It is important to expose the false front of legality which South African authorities attempt to present to the world. This would help mobilize public opinion, especially in those countries which have the power to influence events in Southern Africa in a decisive way. 65. 2.3.1.2 During the Security Council debate, the American delegate excoriated the callous behavior of the illegitimate occupying authority. Although South Africa has cloaked itself in a mantle of seeming legality, he declared in another council meeting, the legal justifications for its actions are spurious. Not only do these actions run contrary to actions by the political organs of the United Nations, but, in addition, the International Court of Justice has also made clear the international responsibility of South Africa with respect to the territory. Its authority was conditioned by the obligation to look to the welfare of the inhabitants. Surely, by applying its apartheid laws in the territory, it did not honor but rather breached that obligation. In still a third intervention, the United States denounced South Africa for not only attempting to annex Namibia, but also extending its heinous policy of apartheid to that territory. And in a fourth council meeting, it deplored South Africa's policy of virtual annexation. It has compounded this evil by applying to the international territory the odious practice of apartheid, with all the miserable human consequences that that practice entails. Nonetheless, the United States opposed international sanctions allegedly because they would likely prove ineffective and would, far from improving the lot of the Namibians, run the risk of making their situation even worse than it is today. 66. 2.3.2 The Security Council requested of the ICJ an advisory opinion on the legal consequences for states of the continued presence of South Africa in Namibia, Southwest Africa, notwithstanding Security Council Resolution 276, 1970. 2.3.3. The court's opinion, delivered in 1971,67 divided, for the purposes here, into two sections, the rationale behind the General Assembly resolution terminating the mandate, and the competence, power, of the Assembly to terminate the mandate. 68. 2.3.3.1. The advisory opinion first sketched in the background to the General Assembly's decision to terminate and declare illegal South Africa's occupation. It noted that throughout a period of 20 years, the General Assembly called upon the South African government to perform its obligations arising out of the mandate, that the Assembly passed a succession of resolutions beginning in 1946 reminding South Africa of its obligations and urging it to comply with them, that the United Nations undoubtedly conducted the negotiations in good faith, yet even the compromise proposals moved by it were rejected by South Africa, and that further fruitless negotiations were held. The court then concluded, in practice, the actual length of negotiations is no test of whether the possibilities of agreement have been exhausted. It may be sufficient to show that an early deadlock was reached and that one side adamantly refused compromise. In the case of Namibia, Southwest Africa, this stage had patently been reached long before the United Nations finally abandoned its efforts to reach agreement. Even so, for so long as South Africa was the mandatory power, the way was still open for it to seek an arrangement. But that chapter came to an end with the termination of the mandate. 69. 2.3.3.1.1. In his separate opinion, Judge Dillard, of the U.S., pointedly observed that negotiations become a mockery if the core assumptions of the contending parties cannot be reconciled. It is apparent that no negotiating process can be successful if the parties are at odds as to the fundamental basis on which the process rests. Quite obviously, negotiations based on conflicting premises qualify, at best, as an empty time-consuming pageant and, at worst, as a mere dialogue of the deaf. 2.3.3.1.1.1. In the passage preceding these remarks, Dillard rebukes South Africa for its disingenuous negotiating posture. The dilemma is focused on the negotiating process consequent upon the dissolution of the League of Nations. Although South Africa was under no duty to submit to the trusteeship system or to negotiate a specific trusteeship agreement, yet, as a member of the United Nations, she was surely under a duty to negotiate in good faith with the United Nations concerning a viable alternative either within the trusteeship or outside it. In the corresponding footnote, Dillard contested a fellow judge's opinion that even if a member state of the United Nations is bound to consider in good faith an assembly resolution, it does not entail a true legal obligation. I cannot agree with this conclusion. The use of discretion and freedom to bargain which the system may confer does not imply the right to exercise an attitude of uninhibited freedom of action which would be tantamount to operating outside the system. 70. 2.3.3.1.2. In his dissenting opinion, Judge Groh, although gainsaying that either the General Assembly or the Security Council had the power of revocation of the mandate, nonetheless concurred that South Africa was under legal obligation to negotiate in good faith. The relevant passage merits lengthy quotation as it lends unexpected support from a dissenting judge to the majority opinion on the decisive point of good faith. The conflict of standpoints can be roughly summarized as follows. The aim of the United Nations was to arrive at the negotiation of a trusteeship agreement, whereas South Africa did not want to convert the mandate into a trusteeship. It is necessary to determine which party has been misusing its legal position in this controversy on the extent of the obligation to negotiate. If negotiations had begun in good faith and if, at a given juncture, it had been found impossible to reach agreement on certain precise, objectively debatable points, then it might be argued that the opinion of 1950, finding as it had that there was no obligation to place the territory under trusteeship, prevented taking the matter further, inasmuch as the mandatory's refusal to accept a draft trusteeship agreement could in that case reasonably be deemed justified. No party can impose its Terms on the other party. Quoting the 1950 ICJ advisory opinion, see supra, 2.1.7.1. But the facts are otherwise. Negotiations for the conclusion of a trusteeship agreement never began, and for that South Africa was responsible. The rule of law infringed herein is the obligation to negotiate in good faith. To assert that the United Nations ought to have accepted the negotiation of anything other than a trusteeship agreement on basis proposed by South Africa, that, coming from the government of South Africa, is to interpret the 1950 advisory opinion contrary to its meaning. In seeking to impose on the United Nations its own conception of the object of the negotiations for the modification and transformation of the mandate, South Africa has failed to comply with the obligation established by the 1950 opinion to observe a certain line of conduct. The United Nations, on the other hand, was by no means misusing its legal position when it refused to negotiate with any other end in view than the conclusion of a trusteeship agreement, for such indeed was the goal acknowledged by the 1950 opinion. It would have been legitimate for the United Nations to have taken note of the deadlock and demanded South Africa's compliance with its obligation to negotiate. This view is reinforced by South Africa's consistent interpretation of its own powers, whether it be its pretension to the incorporation of the territory, something essentially incompatible with the mandate regime, or its contentions with regard to its legal titles apart from the mandate. The legal position of mandatory, formally recognized by the court in 1950, gave South Africa the right to negotiate the conditions for the transformation of the mandate into a trusteeship. Since 1950 that position has been used to obstruct the very principle of such transformation. An analysis on these lines, if carried out by the court and based on a judicial finding that there had been a breach of the obligation to transform the mandate by negotiation as the 1950 opinion prescribed, would have had legal consequences in respect of the continued presence of South Africa in the mandated territory. I consider that, in that context, the legal consequences concerned would have been founded upon solid legal reasons. 71. However, insofar as Groh denied that the United Nations could revoke the mandate, it is unclear what legal consequences in respect of the continued presence of South Africa in the mandated territory he had in mind. 2.3.3.2. After delineating the deadlock caused by South Africa's refusal to conduct good faith negotiations, the court next considered whether the General Assembly had the competence to terminate the mandate, or whether it had acted ultra vires beyond its legal powers. The court decided that it was within the Assembly's province. 2.3.3.2.1. As a general rule, Assembly resolutions are only recommendations. 2.3.3.2.2. The court found, however, that the League of Nations relationship with the South African mandatory included a treaty, contract, component, 72, that it is inherent in a treaty agreement that if one party materially breaches its obligations, the other party has a right to terminate it, and that, consequently, once the League's powers had been transferred to the Assembly, and South Africa had deliberately and persistently breached its obligations under the mandate, the Assembly's competence extended beyond making a recommendation to making a binding legal decision. 2.3.3.2.3. In sum, the court concluded that it would not be correct to assume that because the General Assembly is in principle vested with recommendatory powers, it is debarred from adopting, in specific cases within the framework of its competence, resolutions which make determinations or have operative design. 73. 2.3.3.2.4. In his separate opinion, Judge Nervo enlarged on the Assembly's competence beyond breach of a treaty to make legally binding decisions. The fact that, broadly speaking, the General Assembly's activities are mainly of a recommendatory character does not mean that the General Assembly cannot act in a situation in which it is a party to a contractual relationship in its capacity as such a party. Nor does it mean that, in regard to a territory which is an international responsibility, and in regard to which no state sovereignty intervenes between the General Assembly and the territory, the General Assembly should not be able to act as it did. The General Assembly is the competent organ of the United Nations to act in the name of the latter in a wide range of matters, and in these instances it is the United Nations itself which is acting. This is especially so concerning trusteeship matters, non-self-governing territories. South Africa has in reality and to all effects annexed as its own the territory of Namibia. This behavior is sufficient grounds for the revocation of the mandate. So is the racial discrimination practiced as an official policy in Namibia with the enforcement there of the system of apartheid. Racial discrimination as a matter of official government policy is a violation of a norm or rule or standard of the international community. 74. 2.3.3.3. In an editorial the morning after the ICJ handed down legal consequences for states, the New York Times hailed the historic 13-2 verdict that has cleared away the legal and political fog that for years obscured the status of Namibia. 75. 2.3.4. Later that same year, the Security Council accepted the key findings of the court. 76. The U.S. delegate at the council meeting registered Washington's backing for the conclusions, which declare that South Africa is under obligation to withdraw its administration from Namibia immediately and thus put an end to its occupation, and it also observed that the U.S. position was consistent with our support of practical and peaceful means to achieve self-determination and end racial discrimination. 77. 2.4. It remains to consider if the Namibia precedent can dispel the legal and political fog that has for years shrouded Israel's occupation of Palestinian territory and, in particular, shed light on the means to achieve self-determination and end racial discrimination there. 3.0. Namibia and Palestine juxtaposed. 3.1. In 2002, UN Secretary-General Kofi Annan conveyed to the Security Council that Israel must end its illegal occupation of the West Bank and Gaza. 78. His characterization triggered a swift response from Israel's defenders, who asserted that the occupation was legal until Israel was able to negotiate a successful peace treaty. 79. 3.1.1. In a palpable retreat, the spokesman for the Secretary-General issued a clarification stating that Annan had indicted not the Israeli occupation as such but rather Israel's breach of its various obligations as an occupying power. 80. 3.2. Bearing in mind the sage counsel of Judge Dillard that analogies are always to be indulged with caution, 81. It is nonetheless submitted that in light of the Namibia precedent, Israel's occupation of Palestinian territory is now illegal, as it has persistently refused to negotiate in good faith on the basis of international law an end to the occupation. 3.3. Overlapping historical political context. 3.3.1. A common matrix molded the Namibia and Palestine questions. Both originated in the post-war mandates system, and together they constituted the salient vestiges of that era as the only mandated territories that survived dissolution of the League of Nations without being converted into UN trusteeships. 3.3.2. The UN General Assembly asserted its authority over both lingering mandates. It passed the Partition Resolution, 181, in 1947, paving the way to Israel's creation, and it set out after the 1967 war to complete the unfinished business of creating a reciprocal Palestinian state. In the case of Namibia, the General Assembly early on rejected South Africa's bid to annex it, then claimed title to supervise South Africa's administration of it, then terminated South Africa's mandate and declared its occupation illegal, and finally shepherded Namibia to independence. 3.4. Overlapping legal context. 3.4.1. The Namibia and Palestine questions are juridically homologous. 3.4.1.1. If Palestine is perceived through the optic of the mandate system, then its rights carry over as a lingering mandate. In its 2004 Wall opinion, the ICJ recalled the genesis of the Palestine question in the mandate system, and the permanent responsibility, quoting a General Assembly resolution, that consequently falls on the international community. 82. 3.4.1.2. If the Palestine question is perceived as it emerged after 1967, then Palestine's rights derive from its status as a territory under occupation. The ICJ's 2004 opinion, which deliberated on the legal consequences of building a wall in occupied Palestinian territory, is shot through with references to the Namibia precedent. Point 83. 3.4.2. Whether the mandate system or the status of a territory under occupation served as the point of reference, the self-same principles of sacred trust and non-annexation govern the Namibia and Palestine situations. 3.4.2.1. The ICJ underscored on multiple occasions that the twin principles of sacred trust, that is, the paramount importance of the well-being and development of the mandate population, and non-annexation, that is, the mandatory does not acquire any rights of sovereignty over a mandate, constituted the essence of the mandate system. Point 84. 3.4.2.1.1. Judges Korama, Al-Kaysana, and Al-Arabi, in their respective opinions in the Wall case, located the obligations of sacred trust and non-annexation in Palestine's former status as a mandate. Point 85. 3.4.2.2. The principles of sacred trust and non-annexation also figure as legal hallmarks of a territory under occupation. 3.4.2.2.1. Under international law, a classic text notes, enemy territories in the occupation of armed forces of another country constitute a sacred trust, which must be administered in the interests of the inhabitants. 86. In the Namibia case, the court recalled that in the UN Charter the concept of the sacred trust was confirmed and expanded to all territories whose peoples have not yet attained a full measure of self-government, Article 73, and that a further important stage in this development was the 1960 Declaration on the Granting of Independence to Colonial Countries and Peoples, General Assembly Resolution 1514, which embraces all peoples and territories which have not yet attained independence. 87. These precedents, although invoked in the Namibia jurisprudence, apply with comparable force to the occupied Palestinian territory, as it is subject to alien subjugation, in the language of 1514, and therefore qualifies as a quasi-colonial situation. 3.4.2.2.2. It has also been observed by commentators that the foundation upon which the entire law of occupation is based is the principle of inalienability of sovereignty through the actual or threatened use of force. Effective control by foreign military force can never bring about by itself a valid transfer of sovereignty. 88. Judge Korama, in his separate opinion in the Wall case, pinpointed the essence of occupation as, inter alia, its being only of a temporary nature. 89. 3.4.3. Beyond the principles of sacred trust and non-annexation, the non-derogable right to self-determination also inhered in the legal standing of Namibia and, later, the occupied Palestinian territory. 3.4.3.1. This right derives from the former status of each as a mandate, as well as from the rules governing decolonization after World War II, which ratified the prerogative of colonial peoples and peoples subject to foreign occupation to be independent. 3.4.3.1.1. A prominent commentator observed already decades ago that the Security Council has begun to deal with the Israeli-occupied territories as if they were colonies, while a prominent contemporary commentator places both Namibia and Palestine under the same rubric of illegal military occupation. 90. 3.4.3.2. The ICJ observed in the Namibia case that the decolonization process after World War II left little doubt that the ultimate objective of the sacred trust in Article 22 of the League Covenant was the self-determination and independence of the peoples concerned, while in the Wall case, the court observed after contextualizing its findings in the Namibia precedent that the existence of a Palestinian people is no longer in issue, and that the legitimate rights of the Palestinian people include the right to self-determination. 91. 3.5. If South Africa's occupation of Namibia was illegal, then is Israel's occupation of Palestinian territory also illegal? 3.5.1 Whereas, per Dillard, analogies must be approached with caution. From the standpoints of history, law, and politics, it would be hard to conceive a closer fit than Namibia and Palestine. Both situations emerged historically from the mandates system. Both situations are governed by the foundational legal principles of sacred trust and non-annexation, and both situations fall within the integral political and legal paradigms of decolonization and self-determination. 92. 3.5.2 But does the Israeli occupation of Palestine reach the Namibian threshold of illegality? 3.5.3 The General Assembly terminated South Africa's mandate over Namibia and declared its occupation illegal on 3 counts: breach of international obligations, imposition of apartheid, and failure to negotiate in good faith. An equally compelling charge sheet can be drawn up against Israel's occupation of Palestinian territory. 3.5.3.1 Breach of international obligations. 3.5.3.1.1 The political organs of the United Nations, leading human rights organizations, and respected legal commentators have repeatedly deplored Israel's violations of international law in the occupied Palestinian territory, including excessive and disproportionate use of force, deliberate targeting of civilians and civilian infrastructure, torture, settlement construction, and collective punishment. 93 Many of these breaches amount to war crimes and crimes against humanity. 3.5.3.1.2 These condemnations culminated in the Wall opinion, wherein the ICJ found that Israeli settlements in the occupied Palestinian territory, including East Jerusalem, have been established in breach of international law. The Rome Statute of the International Criminal Court defines transfer, directly or indirectly, by the occupying power of parts of its own civilian population into the territory it occupies as a war crime. The ICJ also observed in its opinion that the route chosen for the wall severely impedes the exercise by the Palestinian people of its right to self-determination, and is therefore a breach of Israel's obligation to respect that right. 94 The right to self-determination is widely regarded as a peremptory norm of international law, from which no derogation is permissible. 95. 3.5.3.2 Imposition of apartheid. 3.5.3.2.1 A growing consensus has emerged, embracing authoritative legal, political, and moral personalities, among them many Israelis, that Israel has established an apartheid regime in the occupied Palestinian territory. The lengthy roster of those making the apartheid analogy in the context of Israel's occupation includes former U.S. President and Nobel Peace Prize laureate Jimmy Carter, South African Archbishop and Nobel Peace Prize laureate Desmond Tutu, and distinguished South African jurist John Dugard, former Israeli Deputy Prime Minister Dan Meridor, Likud, former Israeli Attorney General Michael Ben-Yair, former Israeli Ministers of Education Shlomo Alani and Yossi Sarid, former Deputy Mayor of Jerusalem Meron Ben-Venisti, former Israeli Ambassador to South Africa Alan Lill, veteran Israeli journalist Danny Rubenstein, the Israeli Information Center for Human Rights in the Occupied Territories, B'Tselem, the Association for Civil Rights in Israel, and the Haaretz. Editorial Board. 96 A monograph by South African international law experts found that Israel has introduced a system of apartheid in the occupied Palestinian territory, in violation of a peremptory norm of international law, while an article published in the prestigious European Journal of International Law concluded that a system of apartheid has developed in the occupied Palestinian territory that is not only reminiscent of, but also in some cases worse than, apartheid as it existed in South Africa. 97. 3.5.3.2.2 The reference point of the apartheid analogy is most often the dual system of law that Israel has established within the occupied Palestinian territory that privileges Jewish settlers. But even in the absence of Jewish settlements, the occupation itself would by now constitute an apartheid regime vis-a-vis Israel proper. Some 3 decades ago, noted international law expert Adam Roberts speculated, Israel may see some advantage in the continuation of the status of the occupied territory, because this arrangement provides a legal basis for treating the Arab inhabitants of the territories entirely separately from the citizens of Israel. If a prolonged occupation, in which Israel refused to negotiate a peace treaty, came to pass, he continued, it would pave the way for a kind of apartheid. 98. 3.5.3.2.3 After his notorious recantation and fall from grace 99, jurist Richard Goldstone reinvented himself as Israel's agitprop impresario. In this capacity, he deplored the apartheid analogy on the grounds that there is no intent by Israel to maintain this regime. 100 But if Israel has persistently refused to terminate the occupation in accordance with international law, and if it has sustained the occupation for a half-century, which also comprises the largest part of its total existence as a state, 101 and if it has entrenched an infrastructure designed to make the occupation irreversible, then Israel has, on the contrary, made manifest that it is intent on maintaining the occupation, while sufficient time has elapsed such that Roberts's premonition of an apartheid in the making has become a full-blown reality. 102. 3.5.3.3 Failure to negotiate in good faith. 3.5.3.3.1 An overwhelming consensus exists on anchoring a solution to the Israel-Palestine conflict in international law, on the applicable general legal principles and rules of law, such as the right of both peoples to self-determination, on how to apply these general principles and rules so as to concretely adjudicate the permanent status issues of borders, East Jerusalem, settlements, and, albeit with less precision, refugees. 103. 3.5.3.3.2 In the course of the Middle East peace process, Palestinian negotiators have consistently embraced international law as the framework for resolving the conflict, while submitting concrete proposals that protect Palestinian rights under the law but also make allowance for political expediency. 104 Such as a land swap that would enable the bulk of Israeli settlers to remain in place. 105 Contrariwise, Israel has rejected not only the consensus interpretation of international law for resolving the conflict 106 but also international law itself as a baseline for negotiations. I was the Minister of Justice. I am a lawyer, Foreign Minister Tzipi Livni told her Palestinian interlocutors during a critical round of the peace process in 2007, but I am against law, international law in particular. 107. 3.5.3.3.3 In the Namibia case, the United Nations declared the occupation illegal on, inter alia, 2 intertwined grounds. 1. South Africa refused to negotiate Namibia's eventual independence in good faith, that is, on the basis of international law as delineated by UN resolutions and the International Court of Justice, and, 2. The premises of South Africa's negotiating posture radically diverged from consensus opinion on how to resolve the conflict, that is, Pretoria was determined to annex the whole of Namibia or the prime real estate therein occupied by white settlers. Negotiations had thus become, in Judge Dillard's words, at best, an empty time-consuming pageant and, at worst, a mere dialogue of the deaf. See Supra, 2.3.3.1.1. 1081 would be hard-pressed to find a closer parallel to and precursor of Israel's recalcitrance in the peace process, or to improve upon Dillard's phraseology to describe the resulting diplomatic impasse. 3.5.3.3.4 In other cases adjudicated by it, the ICJ also emphasized the critical role of good faith negotiations. 3.5.3.3.4.1 In North Sea Continental Shelf, the court spoke in its judgment of an obligation to enter into negotiations with a view to arriving at an agreement, and not merely to go through a formal process of negotiation. The parties are under an obligation to act in such a way that, in the particular case, and taking all the circumstances into account, equitable principles are applied. 109. 3.5.3.3.4.2. In case concerning delimitation of the maritime boundary in the Gulf of Maine area, the court pointed up in its judgment the duty to negotiate with a view to reaching agreement, and to do so in good faith, with a genuine intention to achieve a positive result. 110. 3.5.3.3.4.3. In its advisory opinion, legality of the threat or use of nuclear weapons, the court underscored that good faith comprised not only the conduct, process, of negotiations but also an obligation to achieve a precise result. 111. 3.5.3.3.5. It follows from this sampling of the court's jurisprudence that Israel's intermittent participation in the peace process does not in and of itself demonstrate it is carrying out good faith negotiations. To pass legal muster, it must also not thwart discernible progress toward achieving its legally mandated obligation to withdraw. The premises, however, of Israel's negotiating posture which reject not only the consensus application of international law but even international law itself have blocked, and preempt any future prospect of, real movement toward an end to the occupation. 3.5.3.3.6. The principle of good faith is objective in nature, as it is registered in palpable acts or failures to act. The principle of good faith is essentially objective. In application, good faith looks to the effects of state actions, rather than to the subjective intent or motivation, if any, of the state itself. Its violation may be demonstrated by acts and failures to act which, taken together, render the fulfillment of specific treaty obligations remote or impossible, or which defeat the object and purpose of the treaty. Moreover, the principle of good faith cannot but apply also to customary norms having equal status with treaty norms. Thus, states are under an obligation to refrain both from acts defeating the object and purpose of a rule and from any other acts preventing its implementation. 112. 3.5.3.3.6.1. Israel's ongoing settlement enterprise constitutes a case study of bad faith in negotiations, as these ever-multiplying objective facts on the ground are defeating the object and purpose of negotiations, which under Treaties 113 Norms 114 and Principles 115 of international law requires Israel's withdrawal from the occupied Palestinian territory. The Israeli Prime Minister Benjamin Netanyahu publicly supports a two-state solution, but his current coalition is the most right-wing in Israeli history, with an agenda driven by its most extreme elements, U.S. Secretary of State John Kerry observed in his last major address on the Israel-Palestine conflict. The result is that policies of this government, which the Prime Minister himself just described as more committed to settlements than any in Israel's history, are leading in the opposite direction, towards one state. 116. 3.6. Is the UN General Assembly competent to declare the Israeli occupation illegal? 3.6.1. Israel has violated its international obligations in the occupied Palestinian territory, imposed an apartheid regime there, and failed to negotiate in good faith an end to the occupation. It has consequently breached its primordial responsibilities, as an occupying power vis-a-vis Palestine, of sacred trust and non-annexation, and denied the Palestinian people its non-derogable right to self-determination. 3.6.2. If viewed through the lens of the Namibia precedent, the Israeli occupation has become illegal. But does the UN General Assembly have the competence to make such a determination in the case of the Israeli occupation? 3.6.3. The General Assembly has the authority to debate and pass resolutions on the Israeli occupation of Palestinian territory, as well as on the status and contours of the Palestinian right to self-determination. This competence derives from a trio of both general and particular sources. Article 10 of the Union Charter stipulates that the Assembly may discuss any questions or any matters falling within the purview of the United Nations and may make recommendations to the members of the United Nations or to the Security Council or to both on any such questions or matters. The Assembly is the inheritor of the supervisory powers exercised by the League of Nations over the mandates system, of which the Palestine question constitutes unfinished business. In its wall opinion, the ICJ grounded the Palestinian people's right of self-determination in the League Covenant, the ultimate objective of the sacred trust referred to in Article 22, paragraph 1, of the Covenant of the League of Nations was the self-determination of the peoples concerned. Point 117 It is therefore within the province of the Assembly to supervise Palestine's quest for independence. The Assembly presided over, fleshed out the principles and rules of, and played the clinching administrative role in the decolonization/self-determination process that unfolded after World War II, which included ending the subjection of peoples to alien subjugation. 118 In its wall opinion, the court recalled in particular the UN's responsibility vis-a-vis the Palestine question, which has been manifested by the adoption of many Security Council and General Assembly resolutions, and by the creation of several subsidiary bodies specifically established to assist in the realization of the inalienable rights of the Palestinian people. 119. 3.6.4. It remains to inquire whether a General Assembly resolution, which is ordinarily a recommendation, the Assembly is not a legislature, 120 would in these circumstances also be legally binding on all member states. 3.6.4.1. In the Namibia case, it was principally argued that the supervisory powers of the League of Nations over South Africa's mandate had a treaty aspect, that a right of revocation inheres in a treaty, and that consequently the Assembly, which inherited the League's supervisory role, could make a binding legal decision to terminate the mandate after South Africa's breach of its terms. 3.6.4.2. This tortuous reasoning already at the time tested the limits of plausibility. 121 While writers seeking in retrospect to defend the Assembly's competence in the Namibia case have developed other lines of argumentation. 122. 3.6.4.3. In the Palestine instance, such a rationale would constitute an even less persuasive legal contrivance, not least because Israel never entered into a treaty obligation with the General Assembly comparable to South Africa's going back to the League. 123. 3.6.5. The legally binding nature of a General Assembly resolution terminating and declaring illegal Israel's occupation can, however, be firmly established on different foundations. 3.6.6. Judge Nervo, in a separate opinion in the Namibia case, contended that the Assembly's legally binding competence obtained not only in a situation in which it is a party to a contractual relationship in its capacity as such a party, but also and more generally in regard to a territory which is an international responsibility, and in regard to which no state sovereignty intervenes between the General Assembly and the territory. He went on to observe that South Africa's annexation, in reality and to all effects, of Namibia and its policy there of racial discrimination enforced by the system of apartheid constituted sufficient grounds for the revocation of the mandate. See Supra, 2.3.3.2.4. On all these bases, separately and a fortiori combined, the Assembly would also be competent to terminate Israel's occupation of Palestinian territory. 3.6.7. The legally binding competence of the Assembly to terminate Israel's occupation is also implied and inherent in the supervisory function performed by it in the decolonization/self-determination process, of which Palestine, as a territory under alien subjugation, forms a constituent part. If the Assembly lacks such legal competence, it could not effectively fulfill its assigned role of safeguarding the rights of peoples entitled to but not yet exercising self-determination. Isn't a supervisory function bereft of sanctioning powers a contradiction in terms? 3.6.7.1. The cumulative effect of the serial ICJ opinions in the Namibia case supports these contentions. In International Status of Southwest Africa, the court found that safeguarding the rights of peoples under mandates had required a supervisory organ, and that the General Assembly was henceforth the appropriate organ to fulfill this necessity for supervision originally performed by the League Council. 124. In admissibility of hearings of petitioners. The court stated that the paramount purpose of the General Assembly's supervisory function was to safeguard the sacred trust of civilization. 125. In Southwest Africa cases. First phase, preliminary objections, the court found that international supervision constituted the very essence of the mandate. 126. In legal consequences for states. The court found that the Assembly's competence to terminate the mandate inhered in its supervisory powers, otherwise, the Assembly would be impotent in the face of egregious violations by South Africa of its responsibilities, to deny to a political organ of the United Nations which is a successor of the League in this respect, i.e., its supervisory role, the right to act, on the argument that it lacks competence to render what is described as a judicial decision, would not only be inconsistent, but would amount to a complete denial of the remedies available against fundamental breaches of an international undertaking. 127. 3.6.7.2. The upshot of these court opinions is, 1. Protection of the rights of peoples not yet self-governing required a supervisory organ. 2. The General Assembly was the competent organ to safeguard this sacred trust. 3. Absent the power of revocation, the Assembly could not effectively perform its critical supervisory role. Ergo, 4. The Assembly's power of revocation necessarily inheres in the supervisory function delegated to it. 3.6.7.3. Judge de Castro, in a separate opinion in the Namibia case, forcefully laid out the internal logic linking this chain of arguments. He elucidated that insofar as legal concepts such as a trust essentially contemplate the protection of persons, in this case, peoples, who cannot govern themselves, the necessary consequence is the exercise of supervision over the person entrusted with guardianship, supervision of the guardian, and in case of serious breaches of his duties. Fides fracta. The loss or forfeiture of guardianship. Here was no need to mention revocation in the mandate. The essential nature of this concept of trust implies, clearly and evidently, the possibility of putting an end to the mandate. A mandate which could not be revoked in such a case would not be a mandate, but a cession of territory or a disguised annexation. It is difficult to believe that, on the one hand, the working of the mandate system was organized to include a permanent commission to control the mandatory's administration, and that, on the other hand, the mandatory was left free to do what he thought fit, even if it were to run counter to the very nature of the mandate, that one should put him in possession of the territory without any obligation on his part. Any interpretation which denied the possibility of putting an end to the mandate in the case of flagrant violation by a mandatory of its obligations would reduce Article 22 to a flatus vocis, empty words, or rather to a damnable mockery, by giving some color of legality to the annexation of mandated territories. 128. 3.6.7.3.1. Judge Nervo, in a separate opinion in the Namibia case, also derived the Assembly's competence from the functions delegated to it. The General Assembly has had, under the relevant international instruments, several distinct roles in regard to Namibia, and the action which it took in this instance, i.e., termination of the mandate, finds its basis in all these roles taken either individually or together. The General Assembly acted, in its capacity as the supervisory authority for the mandate for Southwest Africa, as the sole organ of the international community responsible for ensuring the fulfillment of the obligations and sacred trust assumed in respect of the people and territory of Namibia, and as the organ primarily concerned with non-self-governing and trust territories. 129. 3.6.8. The General Assembly's competence to terminate and declare illegal the Israeli occupation springs from, on the one hand, its locus as the institution designated by the United Nations to perform the supervisory function, and, on the other hand, the prerogative to sanction that inheres in this function. In the absence of a revocatory power, the Assembly could not substantively monitor the decolonization/self-determination process, of which Palestine is an integral component both as a former mandate and as a self-determination unit under alien subjugation 130. 3.6.9. It cannot be credibly rejoined that the necessary power to terminate a mandate does exist but resides in the Security Council and not the General Assembly. On the one hand, such a division of labor of the supervisory function was nowhere envisaged, while on the other, if the Assembly lacks such competence, then so does the Council. 131. It also cannot be contended that unless the UN Charter explicitly allocated a power of termination to it, the Assembly would be acting ultra vires. In case concerning the Northern Cameroons, the ICJ found that the Assembly had the competence to terminate trusteeships, but it did not ground this competence in an explicit allocation of such power in the trusteeship chapters of the UN Charter. Instead, the court grounded it in the general supervisory functions of the General Assembly in the decolonization/self-determination process. 132. March 6, 10. In light of its past pronouncements, Israel would be poorly placed to contest the binding legal power of the General Assembly to terminate the occupation. When the Assembly debated the Partition Resolution, 181, in 1947, the political body representing the nascent Jewish state posited that in regard to the future of a territory that did not touch the national sovereignty of the members of the United Nations, but instead was subject to an international trust, only the Assembly was competent to determine the future of the territory and its decision, therefore, had a binding force. After its creation, Israel described the Partition Resolution as the only internationally valid adjudication on the question of the future government of Palestine. In a Security Council debate, Israeli Representative Abba Eban, gesturing to the Partition Resolution, boasted that Israel possesses the only international birth certificate in a world of unproven virtue, and that this juridical status arises out of the action of the General Assembly. 133. March 6, 11. On the same juridical basis that it issued Israel's birth certificate, the Assembly is empowered to issue simultaneously a death certificate for Israel's occupation and a birth certificate for Palestine. Judge Dillard, in a separate opinion in the Namibia case, noted that precedents exist for the exercise of such power of termination by the Assembly, and pointed in particular to the General Assembly action with respect to the Palestine Mandate 134. 3.7. The potency of a resolution declaring the Israeli occupation illegal could be fortified if the General Assembly requested, in accordance with Article 96 of the Union Charter, an ICJ advisory opinion responding to the question: what are the legal consequences of an occupying power's failure to negotiate in good faith on the basis of international law an end to the occupation? 3.7.1. The proposed question has been crafted in generic language, along the lines of the question posed to the court in 1996. Is the threat or use of nuclear weapons in any circumstances permitted under international law? If the Assembly requested from the court an opinion specifically on the legal consequences of Israel's failure to negotiate in good faith on the basis of international law an end to the occupation, it could touch on the issue of judicial propriety, that is, an advisory opinion by the court should not be given if it has the effect of circumventing the principle that a state is not obliged to allow its disputes to be submitted to judicial settlement without its consent. 135. The prudent course would be to avoid such a risk, even though the court has only once declined to adjudicate a case due to an implicated party's lack of consent. 136. And even though a compelling brief could be filed supporting a court opinion on a question explicitly naming Israel. 137. 3.7.2. Should the court entertain the proposed question and Israel recycle its preliminary objection in the Wall case, to wit, that a court opinion could impede a political, negotiated solution to the Israeli-Palestinian conflict. 138. This objection would almost certainly gain little traction, not least because the proposed question's very premise is the absence of real negotiations. 3.8. It might still be wondered. What useful purpose would be served by a General Assembly resolution declaring Israel's occupation illegal, even coupled with a complementary ICJ opinion, if an action by the Assembly can be enforced only by a Security Council resolution that, now and for the foreseeable future, will almost certainly not be spared a U.S. veto, while an ICJ advisory opinion is altogether unenforceable. 139. 3.8.1 An Assembly resolution compounded by a court opinion would constitute a pair of formidable weapons in the battle to win over public opinion. They would perform the same role, but with potentially greater persuasive power, as the partition resolution, 181, played in the Zionist struggle for legitimacy and statehood. 140. 3.8.2 Military and political disputes, especially in the world today, Michael Pomerantz observed in the context of the Namibia debate, are never devoid of the dimension of legitimacy as an important component of the conflict. 141 An Assembly resolution combined with an ICJ advisory opinion would constitute an important step toward legitimizing Israel's occupation. 3.8.3 The Finnish delegate exhorted a jaded United Nations to obtain in support of its Namibia resolutions an ICJ advisory opinion. He persuasively argued that it would expose the false front of legality which South African authorities attempt to present to the world, and would thereby help mobilize public opinion, especially in those countries which have the power to influence events in southern Africa in a decisive way. See Supra, 2.3.1.1. 3.8.4 To highlight the salutary effects of an advisory opinion, Judge Weeramantry, in his magisterial separate opinion in Legality of the Threat or Use of Nuclear Weapons, harkened back to the Namibia case. The court's decision on the illegality of the apartheid regime had little prospect of compliance by the offending government, but helped create the climate of opinion which dismantled the structure of apartheid. When the law is clear, there is greater chance of compliance than when it is shrouded in obscurity. 142 Indeed, the joint action by the UN's political and judicial organs in the early 1970s had little direct impact on Namibia's self-determination struggle. It did not attain statehood until some 2 decades later, and only after a massive loss of Namibian life and protracted negotiations. But wouldn't it be perverse to then conclude that the combined efforts of the Assembly and the Court were irrelevant? 143. 3.8.5 Jurist James Crawford, representing in Legality of the Threat or Use of Nuclear Weapons. Several South Pacific states devastated by nuclear testing, likewise pointed to the contribution international law could play in achieving a humane outcome. No one is naive enough to suggest that international law is a sovereign antidote to the risks and dangers presented by the threat or use of nuclear weapons. But neither is international law merely a charlady, a femme de ménage, called in to clean up after the event is over and all the participants have gone home. It can be part of the solution to the problem. But it can only be part of the solution if it is brought to bear on the problem while it, and we, are still around. For the court to declare that the use or threat of use of nuclear weapons is unlawful in all conceivable circumstances would contribute to a solution to one of our greatest modern problems. 144. Couldn't international law also be part of the solution to another one of our greatest modern problems? And, if it is to be brought to bear on this problem, isn't now the time for the international community to act, while Palestine is still around and before it is effaced from the world's map? 4.0 Concluding remarks. 4.1 Deeming it premature to recognize a state of Palestine, the self-same James Crawford observed a while back, the essential point is that a process of negotiation towards identified and acceptable ends is still, however precariously, in place. He then posed as the central challenge, to change the status quo in favor of a comprehensive settlement accepted by all parties concerned, a situation that seems as remote as ever. 145. 4.2 But what if the process of negotiation is just a facade, if there's no agreement on ends, if a comprehensive settlement accepted by all parties is not just remote but unattainable because in Judge Dillard's words the parties are at odds as to the fundamental basis on which the process rests, and if this protracted impasse springs entirely from the occupying powers' comprehensive repudiation of international law. 4.3. As it happens, Crawford does address, albeit obliquely, such a contingency. A state, he opined, cannot rely on its own wrongful conduct to avoid the consequences of its international obligations. 146. Isn't this a precise description of the peace process? By refusing to negotiate in good faith on the basis of international law an end to the occupation, Israel has evaded its dual obligations to withdraw from occupied Palestinian territory, and from a legal and moral standpoint, what's most critical to allow the Palestinian people to exercise, at long last and after so much agony, its right to self-determination. 147. 4.4. It is high time to put an end to a so-called peace process that in reality is an avoidance-cum-annexation process. States, Judge Jessup said in the Namibia case, are not eternally bound by the old adage, if at first you don't succeed, try again, see Supra, 2.2.4.3. The moment of truth is once again upon the United Nations in the Uruguayan delegate's words to put an end to the struggle between law and arrogance, see Supra, 2.2.5.3. 4.5. The UN General Assembly can and must declare, finally and conclusively, that the Israeli occupation, not just this or that constituent of it but in its essence and totality, is illegal and that a full Israeli withdrawal will no longer be held hostage to an interminable negotiating process, the manifest purpose of which, after decades of trying and trying again, can no longer be in doubt, except to those willfully blind, that purpose being to make the occupation irreversible, and to consign to oblivion the people of Palestine.